I am beseeching your lordship, my lord, but there are certain matters that are vacancy matters, and the matter your lordship will recollect that they entered certain quantity in the EPOS machine, they do not have. Your lordship are directed for consideration of the representation. Similar matters are, my lord, let it appear tomorrow. I mentioned matters will take 5 minutes, my lord. All the matters can be discussed.
How many matters are there?
14 matters.
14 matters.
All representations, 12 representations to be considered, and 2 vacancies has to be stated. I do not know whether files will come or not by this time.
Yes, tomorrow I have some other determination. That is the dispute.
It will take 5 minutes, my lord. Kindly keep it at 10:30. It will take 10:35. It will be over.
Second appeal matters are there. This is the issue.
I would not have beseeched your lordship had it be taken up on Monday because your lordship will not be there.
Yes.
That's why, my lord, I am saying it will take 5 to 10 minutes only. One order will cover all the matters. Representations all of one date.
Okay, mention matter. Tomorrow mention matter.
Deeply over. No, Hailas. Notun.
Yes, call the list.
My lord, I am for the respondent, my lord.
Yes.
The affidavit as directed has been served upon us yesterday. Because there was a direction to file affidavit and leave had been granted to prefer an exception if needed. My lord, kindly extend the time.
My lord, I am filing the affidavit, my lord.
1 week to file the exception and kindly let the matter come up in the first week of January. And my lord, kindly direct them to give us a legible copy of page number 7, 8, and 9. Of
My lord,
the
I will,
affidavit.
I'll give that. I'll give.
Affidavit file on behalf of the respondents.
My lord, I'm
Containing all English translation.
I'm seeking my lord's leave. My lord, I have another matter in another court. May I be grateful.
Containing English translations of the documents written in Hindi vernacular.
My lord, on the last occasion, lordships raised some queries about the delivery of the dismissal order of the to the petitioner, my lord. That was also, my lord. That is also, my lord, in the record, my lord.
Written in Hindi vernacular, together with some postal receipts be kept on the record. নাকি প্রথম থেকে কি করলাম এফিডেভিট
Respondents containing English translations of documents written in vernacular and postal receipts
be kept in the record. Copy served. Petitioner leave to file reply, if any, within a week. Full stop. Let the matter appear in the list under the same heading on 9th
Of January, my lord.
9th of January,
Deeply obvious.
2020.
My lord, let the copy, advance copy of the exception be served upon the respondent, my lord, if there is it is.
Okay. কি বলো? না, within a week. Within a week বলেছি না? Within a week, after supplying an advance copy to the respondent.
Deeply operational. Deeply operational.
I appear for the petitioner, my lord. Both institute matter. Keeping our reply, my lord.
Yes. Mr. Sannal has concluded, I think.
No, Mr. Shannal will be making just today's digital submission, therefore we will finish today itself. Last occasion, we have completed 80% of our submission.
Mr. Sannal has to conclude. Thereafter, Mr. Bandopadhyay has to argue in this matter.
Mr. Shannal is on legs in court number 2.
Okay.
If my lord so desires, can give half an hour short pass over.
No, I have some fixed matter.
Your Lordship, kindly then take it up next week, Thursday,
Next week, you are appearing?
for the respondents, Bose Institute,
Both institute. No, this is a part-heard matter. I
part-heard
have
matter,
this
Your Lordship.
Next week, it is not possible to heard.
Or if your lordship so desires,
After reopening,
but I can start. There is no difficulty. But Mr. Shannal will be making the submission.
Yes.
He requested me that so that the matter is going on in court number 2.
I can pass it over, no issue, but I have some fixed matter at 12:30. 12:30.
then kindly take it up at 3, Your Lordship. We all will come back.
I have
If a
some-
fixed time is
I have
given,
I have a division bench.
oh, Your Lordship,
Second half.
then kindly let it go after the vacation.
I think if they fix it up 11, my lord, he will be coming in the meantime. I told him.
We are going to touch the 11 now.
That's half an hour.
Okay, let it pass over.
My Lord.
Lord, may I just humble your lordship just once, lordship? Lord, it's not lordship on the last occasion, lordship. So, lordship, kindly pardons me, lordship. Lordship, on the last occasion, lordship had heard one matter, and lordship directed us to file the written notes of arguments. Lordship, may I just file the written notes of arguments?
Only you file the written notes, hand over it.
Oh, lordship.
That will be sufficient, not necessary to mention or otherwise.
Lordship,
I have
kindly.
already given opportunity to file in the
Oblige,
office.
oblige. Yes, lordship, the case number is.
Case number is there.
Yes, lordship, on the
Very-
last occasion.
very well,
Last week.
It will,
Oblige, lordship.
it will reach to my chamber, no issue.
Lordship.
My lordship, I am for the petition in this matter. My lordship, 156 is related to the Bose Institute matter, my lordship. As it is passed over, my lordship, then
Okay. 156, 157, 158, 159. All are the Bose Institute matter. Let it pass it over.
160.
permit
Yes.
get the file. Permit me to 1 minute.
Call someone to get the file. Give me the. Okay.
File the type it up. Follow.
I am appearing on behalf of
These, the point raised by the respondent authorities that at the time of moving of the writ application before the Honorable Justice, the point was raised by the learned counsel appearing on behalf of the state respondents that it was registered by the Companies Act, so writ is not maintained. That point was heard by the Honorable Justice Amrita Sinha, and leave was granted for filing the on 16 March 2015. It was heard.
Show me the order.
I have
Order dated.
16 March 2015. Your Lordship kindly come to my supplementary evidence. Order dated paragraph 4 on 16 March 2015. No, on 2nd July 2019, the Honorable Justice Amrita Sinha has given liberty to file a supplementary affidavit and pursuant to the state order passed by her Lordship, this supplementary affidavit was filed only to point out that the authority concerns if there be any vacancy created under the state authority, that is the West Bengal Women Development Organizations, that was filled up from other wings of the or other department of the West Bengal government. And I have annexed 2 documents, that is annexure P1, page 3, and annexure P1 is page 6.
Page 6 of page 6 of
supplementary.
supplementary.
That from other department of the West Bengal government, it was transferred to the this department. And second, thereafter another word is passed by the authority concerns, transferring the post was created under the which was created under the state organizations, that was filled up from the CD that was filled up by the other departments from the West Bengal government. And time to time, initially they have taken a policy decisions which is under challenge 2009, that if the promotional post is created, that will fill up by the other department of the state government, state of West Bengal. And subsequently, on the basis of that policy decision, which was issued in the form of circulars issued, which is under challenge before your Lordships, that due to these policy decisions taken by the authorities concerned, time to time, if any vacancy was created under the state authority, that was filled up from other departments of the government of West Bengal. As a result, my client is a upper division clerk. The promotional post is administrative officer. That can have any opportunity was given to by the authorities to avail the opportunity for upgradation.
No, where is the promotional avenue of the writ
Promotions as an
petitioner?
administrative officer.
No, where is the structure? You have admitted, you have appointed as a LDC, LDA,
Upper division clerk.
LDA.
UDC.
No,
Upper division.
LDA, creation of
LDA.
post is LDA.
LDA.
Promotional
Next
avenue is
administrative officer.
UDA, not administrative officer. UDA is the last. Thereafter, you cannot go to the officer's post. There is no such construction of your appointment.
Last occasions I have submitted before Lordships as per defined compulsion of circulars.
These are of different departments.
Defined departments under the state government. It is a government undertaking, and it was they have to ought to follow the rules and regulations which was issued time to time by the concerned authorities. That is the government undertaking is always follow the rules framed under the state government.
No, certainly not.
State government.
Certainly not. It is governed by
It appears from the post created that they are entitled to get the all benefits and the rules time to time issued by the authority concerned by the state government that has to follow by the concerned authorities.
No, when you appointed as a LDA,
LDA
you are appointed as a LDA.
post was created by the state government.
Yes, LDA. Thereafter promotional avenue is up to UDA. Not more than that.
UDA.
Yes,
I was promoted in the year
UDA.
2012, UDA.
When you
Upper
promoted,
division class.
when you promoted to the UDA, when you
Thereafter,
promoted,
next promotion post administrative officer.
you show me any circular that you have the,
submitted that.
I know, you just,
Administrative officers. Circulars.
show me circular that the UDA may be appointed as an administrative officer.
Yes, I've compulsions of several.
No, there is the several departments. Your appointment, your construction of your department, where is it?
Administrative officer that was filled up by the other concerned departments, others government department, other departments of the state of Odisha. It is the policy of the government taken that the upper division class by promotions, they have an opportunity to go to the higher post, that is administrative officers. I have annexed all, I have submitted in the form of compulsions of all circulars before the office, and it was filed last occasion by my learned junior, that 1st July 2024. Your Lordship can see the by promotional post upper division clerk to they are appointed as the administrative office. My rights was curtailed in this way. For this reason, I filed this application under Article 226 before this Honorable Court. Initially, it was moved before the Honorable Justice Amrita Sinha. The point was raised that these applications are maintenance because it was registered under the Companies Act. Thereafter, after hearing the petitioners, after hearing the matter, his lordship admitted that it is permissible, it is entertained, and thereafter direction it was placed for hearing. And finally, it was on last occasion when I have submitted before lordship, your lordship was pleased to ask me to refer some circulars that upper division clerk
কি দেখাচ্ছে
entitled for administrative officer.
কোনটা এটা কি দেখাচ্ছে
And 1st July 2020. 1st July
এটা কি?
2024, page 26.
সাবজেক্ট এটা কি জিনিস
Compulsion of circular.
কম্পাইলেশন সার্কুলার দেন কম্পাইলেশন সার্কুলার না এটা তো নোটস দিয়েছে কম্পাইলেশন সার্কুলার
Director of Health Service, Government of West Bengal. 1st July 2020. Right of authority for promotional post to next higher post to administrative office.
health of that is different thing and it is company, my lord. He's working under company. It is the government of West Bengal, my lord, and it is the purely government employees. He is not the pure government employees. Government employees and the
It was created
employees
on
of the government
basis-
undertaking
Post was created on the basis of the order passed by the state government.
are certain different,
State government.
different
Neither
things.
mislead the court.
There is no question of misleading the
Yes.
court. The concept is totally
Initially,
different.
It was
Yeah.
submitted on behalf of the learned friends before the Honorable Justice Amrita
No,
Sinha.
sir, where is
And
where is the record? Court has simply direct to file
Under
affidavit.
circumstance, if
Only
organization
granting-
financially,
Granting aid will be provided.
salary, everything is
No.
under the
Only granting aid. I have shown, my lord, that only
The
granting.
state authority is running under the financial assistance of the state government. They ought to follow the
The
rules and
Tram
regulations
suppose,
framed by the state
just a minute. Suppose my lord transport company, your lordship knows very well that West Bengal State Transport Corporation
some dole has been given by the government. That means the employees of that organization is the employees of the government.
Post was created by the government, by the state of.
No,
state
I
of
understand. Let me see the construction of your undertaking. This is a West Bengal
Post was.
Women Development Undertaking.
Yes.
True? Is it a, is it
Yes,
an
madam.
undertaking?
Yes, it is an undertaking.
What is the office you are joining as a UDA or
Your
LDA?
lordship, kind of paragraph, I'm thoroughly submitting paper, lordship. On paragraph 2 of my writ application, on 20th February 2006, the Joint Secretary of the Government of West Bengal, Department of Women and Child Development and Social Welfare, and social welfare such and such date duly intimated to the Account General Treasury Building in respect of creation of post. Post was created by the state government by the order.
No, no, you are just going otherwise. I am just asking some question to you for my satisfaction. You just please answer these. You are appointed as a post of lower divisional assistant where? Whether it is a secretariat or it is a directorate or it is an undertaking under the director. Undertaking under the director. So what is the directorate? What is the name of the directorate?
It is the
Director of Social Welfare, West Bengal, Managing Director.
Women and Children Development Organization Department has 6 wings: Social Welfare Board, Women Commission, Director of Social Welfare, West Bengal Women Development Undertaking,
Yes.
and Director of ICDS and Director of Child Rights and
So what is the
that is the 6.
you are under
West
I am
Bengal.
West Bengal 4.
you are under
West
West
Bengal-
Bengal
West
Child
Bengal Women
Development
Development
Department.
Yes.
West Bengal Child Development
It is
Department.
under the control of Women Child Development Department.
It is an independent entity. Social Welfare Board is an independent entity, and also West Bengal Women.
that is
Yes,
right.
yes. It is created under 617 of the
Post was
Companies Act.
created by the
I am-
state
I am-
government.
Yes, I have.
Very much
I have.
realized.
Yes, read lies. Who? Yes, read lies. Who can deny the
And
read?
everything, post was created, everything was.
When the post was created, when you permanently absorb in the undertaking, you are you are within the knowledge regarding the
Yes.
alleged circular you have challenged.
And whenever, my lord, he has accepted the promotion in the light of earlier
Not
notification,
promotion. When you are
Yes,
just
yes, he
confirming
knew
the
it.
service,
he knew everything.
you know that the circular was there.
Circular, I was joined in the service in the year 2007. as a-
Yes, when you confirmed in the service,
2007.
no,
So,
you just seen
2009.
your document.
2009.
Confirmation to that. What is order page 33. 2003 Council Sarkar, Son of
Yes,
Sarkar,
2010, page 33, mal. 8th April 2010.
Then
Thereafter, he was promoted.
you
to
have
the
completed
upper
3
division
years
clerk.
of service. Thereafter, on satisfactory service,
The losses
you have
service
declared permanent.
is declared permanent with effect from 23rd March 2010.
Yes.
And very next page,
And
kindly
in
see,
the
my lord.
year next page.
And the circular you have challenged of 2009.
Your lordship, kindly see the next
After
page.
accepting the
Page.
benefit.
And subsequent order passed by the authorities time to time.
Managing Director.
Your lordship, I'm submitting after doing submission. Next page, page 34. He was promoted to upper division clerk.
Yes.
Thereafter, he was promoted to
KBS. Managing
I
Director.
can say,
Documentation.
That is 30th March 2012. Chief Sarkar is presently working as lower division assistant in the scale of pay PV2 with grade of such as attached to office of the West Bengal Women Development Undertaking. He is appointed through promotions to the post of upper division clerk assistant in the scale of pay such and such with effect from the date of his joining.
I'll kindly see that who has issued this. Managing director of the company, undertaking. If it is she is saying he is just like government employees, then government will issue the promotion letter. And he is blowing hot and cold at the same rate. One hand, he has accepted that promotion, and later on, he is challenging the earlier notification.
And it appeared from Circular Plus your losses kindly come to page 30. At the time of issuance of upon the later order passed by the West Bengal Women Development Undertaking, that allowance and admission part West Bengal state government and all the facilities entitled to get the all benefits as entitled to the other employees of the state government. All the benefits which is entitled to get the benefits of other West Bengal state government rules. And if I can search, particular to declare corruption. The policy decision was taken. It also affects the rights of the petitioners. Time to time, even circular is issued by the authority concerned by several orders passed by the authorities. The promotion post was created and that was filled up by the authority from the other
These are the purely government departments. You are showing that departments, that is
other wings,
not wings. These are the
Other
purely
wings,
secretariat and
under the
directorate.
under the control Women and Child Development Department.
No, sir, I know, understand your grievances, but your grievances cannot be redressed as you are serving under a department and not directorate, not secretariat. If you are under the within a directorate, I can understand, or secretariat, I can understand, but you are working under a director.
Women, it is under the control of Women Child Development Department.
I understand control.
It is under the
There are
control
several departments, several undertakings
department.
of a department, but all the same undertakings are their own associations, own rules, not at par with the government
By
rules.
the Women and Child, the rules
Yes.
under the
All the rules, all the circulars of the government cannot be applied in this case. Moreover, you have appeared before this court after a long period. How can we understand that you have the grievances, rightful grievances? 2009 notification you have challenged and you have joined in the service.
policy decision.
Yes, policy decision
Otherwise,
running.
I have the right to.
So it is running
that
since
should be challenged.
it is
by
running
the
since
authority
your joining.
on the basis of the policy decision taken by the authority. Time to time, different circular issued by the authority concerned to fill up the promotional post from other departments of the state government.
This is the total system
And subsequent
of the
order, policy
undertaking.
decision was taken by the authority concerns in the year 2009, that is under challenge, and subsequent order passed by the authority.
Moreover, in the writ petition, how can you challenge the policy? when it is not truly ultra virus.
This affects the rights of the petitioner.
You know your right is not there.
At the very initiation.
You know
They have
there
to
are no
follow
right.
the facilities and others promotional policy which is adopted by the state government.
Government.
Adopted, but
Similarly, we are
when you join in the department, you know there is the policy, what is the promotional avenue, everything you know.
after promotions, I came to know that this policy was adopted by the.
Policy was adopted earlier you're joining in the post.
I joined in the year 2007.
Yes, you are confirmed in the 2010. There, previously the policy was taken by the government. Now, how can I say the government you have taken a wrong policy?
The vacancy was created, but it does not fill up.
No, there is no
On
vacancy.
promotional after
No, you can show me prior to you in the said department, in the said undertaking, is there any provision that the UDA should be promoted to the administrative officer? Is there any instance apart from the other
I
departments?
take instruction, your losses kindly take this matter, and next Thursday I will take instruction for my client.
Do you understand my query? Is there any instances in your undertaking? Such what happened earlier. But I think there will be no there. The LDA has been created and you are the first person joined as a LDA. The post of
I take
LDA.
instruction, your losses kindly take this matter. Yeah, you might go. It will no one. How pictures the chief photo can take the like take the get that. That's good. What do you have to do? Taking over the budget. And I have that the photo. Something like that. এর মামলাগুলো হয়নি আগের মামলাগুলো হয়নি থেকে বেরিয়ে দেখে 160 চলছে হয়নি তো আমি একটু পক্ষে দেখছি একটা তো ফিক্স আছে 12টা না ছাড়া কি বলবো undertaking is super existing. Yeah, to follow just the own জানেন না এতদিন আজ ট্রান্সপোর্ট ডিপার্টমেন্টের নিজস্ব রুলস নেই তাদের নিজস্ব হ্যাঁ এখানে তো আন্ডারটেকিং articles of association they are guided by women child development department it has their own rules articles of association memorandum ঠিক আছে অবশ্যই that every wrong তো
Some document you have placed with the supplementary.
and supplementary has been filed my lord when
Transferred to the
entire
post
matter
as-
is ready for hearing at during the hearing stage here.
Let me understand. Yes, supplementary you have filed some transfer posting of the
in the-
officers.
in the concerned women development
This is the transfer order
transfer
of the
order
officers.
and posted to the project manager in the women's development act.
So in page 6, DPO was transferred as a project manager. all the officers post. They are not the UDA.
My submission is that the policy decision was taken that the promotional post was created, administrative officer, that is annexure P2, that was built up from other, that is annexure P2, other wings of the women child department and social welfare.
You have annexed some document of transfer of officers to the other officers of other department.
দিয়ে দেখান যে অন্য কাউকে নেওয়া হয়েছে
I'll take instruction.
Yes.
and your lordship knows that court cannot
But that
direct for any
discriminations-
create any supernumerary post in this field while there is so many judgment delivered by the Supreme Court.
Yes, what matter?
Well, court cannot direct to create any supernumerary post.
Naturally,
Yes.
if there be any.
No, he is not
Natural
asking for
justice-
supernumerary post. He is saying that the notification which he challenged, administrative officer's post has been created, but it has to be filled up by the other departments, by the officers of other departments.
But the other wings of the-
that other wings,
Other wings of the government office, everything is there.
that is the-
But is there any avenue that the
he has to show malad
Upper
from the
division
same
assistant.
undertaking any other malad UDA has been posted to the official post.
same
yes,
undertaking?
other
Then the
department.
question of
Other
article,
department of the state government.
other department is different. They have,
Policy-
it is
If
a
you can
purely
show that the
health department
UDA
is
was promoted to the other department as a administrative officer,
I-
that is health
Depends
department.
on
Health
the
department is a
issue
purely government department.
completion circulars. UDA. I have to annex all the documents, all the circulars. 7 circulars, because UD is permitted to appoint as
In,
a
in this
assistant
department, in this undertaking,
assistant.
you are working in a
Same
particular,
rules should be followed.
no,
Policy.
government employees and employees of undertaking is a different entity. At this stage, I hope, Mr. Shah, you will understand the difference between the government employees and the
I
employees
know
of the
that, I
undertaking.
know that.
Yes.
Government has limited.
They are guided by their own rules.
all officers, you have annexed the notifications, compilation of 7 notifications.
Yes,
In
They
all
are
notifications,
they're appointed as by promotion as a assistant, as a.
all
assistant
officers are promoted. All officers are promoted.
Justice can see the I'm one by one circulars compassion. 1st July 2020.
এটা কোথায় কোন কিসে দিয়েছেন এটা
Page,
Page 6. Compassion of circulars, page 6.
compilation,
Compassion of circulars. That's the business mind. 59. Head clerk. In order to fill up the vacant posts of administrative officers in different districts under regional setup of Directorate of Health Services,
purely
WP, all heads or of officers are requested to issue these circulars among
Director
the employees
health service.
presently holding the post of head clerk. Here, a head assistant 2, head assistant 1 or equivalent posts including UTA, UTC, date of joining as such and such or before such and such
Director of
under their
Health Service.
administrative control, asking them to submit options for promotion to the post of administrative officer.
yes, there are avenues. There are avenues in the department itself, that there are some promotional avenue in the department.
Yes.
But in your department or in your undertaking, there are no such avenue.
My rights was started upper division clerk was
You knowing your right, you have joined the post.
after promotions, I had further promotion or post was created, but it was filled
No,
up by.
in all departments of
my-
government of West Bengal, I
That
know,
is my case.
all the department government of West Bengal, purely the secretariat and the director. There are avenue that one LDC, lower division clerk, can be promoted to the UDC and administrative officers. That is not the issue. Issue is that there are some promotional avenues. There are some direct recruitment and jump promotion. Everything is there within the scheme of the government. But in your undertaking, there are no such scheme.
But they are created as a promotional post.
Not created
Administrative
promotional
officer.
post. They have
That was
created a post and they have settled the rule
They have
that
created the
that
post.
has to be filled up by other department.
That is the illegal.
This is
illegal
the policy.
decision making. My rights was curtailed for further promotions. That is also violation of natural justice. Article 14. For this reason, I filed this
Article
application
14
before
is
this
if
honorable
there is
and
a
I
discrimination, you
wide,
go before the-
wide application.
yes, you show
The
before the
authority
honorable
cannot
court
treat it as a
that other similarly
uh,
situated
cannot
employees have
cut
been
the right to
given.
work. That is a fundamental right that cannot be curtailed by issuing this one.
Very well, I am passing the judgment. Order. Please take down. State of West Bengal has created a post of lower division assistant for the office of West Bengal Women Development Undertaking. West Bengal Women Development Undertaking. Petitioner applied for the said post and he was appointed as LDA on 12th of March 2007. Full stop. After 3 years satisfactory service, with the department, he was made permanent with effect from 4th of April 2010. He got his first promotion on 30th March 2012 to the post of upper division assistant. Date বলেছি 30th March to the post of upper division assistant. Since then, he was serving with the department more than 10 years. But the department, though have created a post of administrative officer, but issued the circular that the said post of assistant project manager stroke administrative officer would be filled up on deputation by an officer belonging to West Bengal Junior Social Welfare Service. The impugned circular dated 26 May 2024 to 26 May 2009 is under challenge before this court. It is the case of the petitioner that the circular itself has stalled his promotional avenue as an administrative officer. It is the further case of the petitioner that the action of the state respondent is illegal and arbitrary. The promotion at the next higher post in the office of the West Bengal Women Development Undertaking, that is the post of administrative officer, should be filled up from the post of upper division assistant. Mr. Saha, learned counsel, appearing on behalf of the petitioner, submits that the government that the present petitioner is a government employee, and the state of West Bengal has framed the rules for promotion of the UDA to the post of administrative officers in different departments. Impugned circular actually stalled the promotional avenue of the petitioner by such the fundamental right no, the petitioner, though the similarly situated persons, that is the other other employees of the government of West Bengal in different departments under the same post of upper division assistant are being regularly promoted to the post of administrative officer. In that score, the fundamental right of the petitioner under Article 14 has been violated. Thus, the period for quashing of the circular dated 26 May 2009. In support of its contention, different circulars of different departments were placed before this court. Mr. Paul, learned counsel, appearing on behalf of the state authority, has submitted that the instant writ petition is misconceived. The West Bengal Women Development Undertaking was incorporated under the Companies Act 1956. there are some separate articles of association to guide and form the association. Full stop. As per clause 4 of the article of association of the said undertaking, it is a government company within meaning of section 617 of the Companies Act 1956. It further argued that the functions of West Bengal Women Development Undertaking are undertaken by receiving fund as grant in aid from the Department of Women and Child Development and Social Welfare, Government of West Bengal. For smooth functioning of the said undertaking, the governor has time to time created the post the article of association had specifically mentioned how the said post has to be filled up. The cabinet has approved regarding the mode of filling up the post. According to the said approval, lower division assistant can be filled up through employment exchange. UD assistant can be filled up generally through promotion from the suitable candidates working in the feeder post as a confirmed employee LDA in the fixed scale. Full stop. The assistant project manager stroke administrative officer can be filled up by deputation of an officer belonging to West Bengal Junior Social Welfare Service who will be comparatively junior with grade. Mr. Paul further argued that the present petitioner was appointed as lower division assistant and he was promoted to the post of upper division assistant. He further submits that the governor has the only authority for creation of posts in the departments. There are no promotional posts for the post of UDA in the same undertaking, and therefore question of awarding further promotion to the petitioner doesn't arise. Full stop. Having heard the learned counsel for the parties, also considering the fact, it appears to me that the petitioner was appointed as lower division assistant under the West Bengal Women Development Undertaking. He was promoted to the post of UDA. On 30th of March 2012. Since then, he was he is serving under the same post for more than 12 years. Admittedly, the several departments of government of West Bengal has some promotional avenue of UDA, upper division assistant, to the post of lower feeder of officers, that is administrative officers. But it is true that West Bengal Women Development Undertaking is a government company purely run under the granting aid. Pay structure, service benefits of the employees of the said undertaking are being guided by the rules of the government of West Bengal, but the structure and the promotional avenue has been specifically framed under the association of the said undertaking. Full stop. The petitioner had joined in the post in the year 2007 on temporary basis. Thereafter, his service was became permanent in the year 2010. The circular, Alice circular, which is under challenge before this court, is issued in the year 2009. That is much prior to his service became permanent in the department. The petitioner was well aware about the fact that in the said undertaking, he do not have any promotional avenue after the post of UDA. I know that the promotional avenue of the petitioner has been stalled, but the petitioner was well known about his service tenure and service facilities before joining in the post. Moreover, the circular issued by the Alice circular issued by the government of West Bengal, each of year 2009, first of long 15 years has already been elapsed. Now the petitioner cannot challenge the said circular issued by the government of West Bengal when he was always aware about the circular before joining in the post. Under the above observation, I am of a view that the rules, I am of the view that the promotional avenue of the government of the office of the employees of the government of West Bengal in different departments cannot be at par with the promotional avenue of the West Bengal Women Development Undertaking. Thus, I find no justification to entertain the present petition. Under the above observation, the instant writ petition is disposed of. No.
I think Xerox certified copy.
Yes. Yes.
Just starting. Just starting.
I'm Giri.
Although the substantial hearing has been done, my lord, only two things, my lord, I should place, my lord. If my lord kindly can three of my item number 154. Oh, so,
Can 3.
can three. Just I will be taking two things, my lord. If my lord kindly sees the repetition first, my lord. Kindly sees the repetition, page 93 is a memorandum issued by the finance minister for formation of group of officers, where my lord has elaborated the last location we have stated. Then comes to page 96. That is the first minute of the group of officers. Page 96. Page 96. Then I'm taking use of it. Kindly see this document.
96.
Minutes of the group of officers, my lord. Group of officers, names are given, invitee from DST given, representative from both institute. They are given, my lord. In pursuant to DST's OM number 22 dated constituted group of officers in respect of both institute, whereby it is held in the first meeting in Technology Bhavan, New Delhi, on so and so, Dr. So and so, on behalf of the DST, welcome so and so, the chairman and all members of the group of officers. And after formal introduction of members, invitees present, started the meeting with the permission of the chair. The representative placed the desired information as called by the AI division, DST, email dated so and so, before the group of officers. On perusal of the furnished document, the group of officers observed that the technical administrative employees of both institutes were having service conditions such as time scale promotion as per both institutes. OM number so and so dated. From the content of the OM dated so and so, group of officers found that the order was issued to have pay and area advancement structure parity that of the employees of Indian Association of Calculation Science. The date of implementation of the order has been taken on so and so as that of the ISCS Kolkata. After deliberating on the furnished information, group of officers observed in compliance to so and so dated had opined that it would be better to have a chronology of events from the both institutes which lead to adoption of the timescale promotion in lieu of vacancy-based promotion to its employees with effect from so and so. The document related to the origin of structural reforms committee, such as need of the structural reform committee, its constitution, its mandate, minutes of its meeting, final recommendation of the SRC, its acceptance and approval by DSP, the reasons for bringing changes in the designation of the post of both may be brought. The difference in service condition of the employees of both institutes before and after so may be brought out in a clear terms, including role and responsibilities of the post, pay structure, promotion, and policy, etc. Keeping in view of the duties and responsibilities of the post of both institutes with that of the corresponding pay scale, both can propose for revised pay scale of respective posts in 660 and 760, along with detailed justification for consideration on zero. While making such proposal, it shall ensure that the final package of benefit proposed for the employee shall not be more than beneficial that admissible corresponding category of central government employees, as per DOE web issued from time to time. For better appreciation, mapping in tabular form may be submitted showing the pay structure and the post with duties and responsibilities prevailing with the structure of pay prevailing in any government of India lab organization such as DRDO, DAE, preparation for technical staff and administrative. This was the suggestion given from the group of officers. The employees of the both institutes no moto has not come with that proposal. It was the tabular structure was to be given by the post institute itself, which the post institute has given in that is the annex to the reply itself. I'm led by Mr. Shanal.
Yes.
For the last two occasions, Lord, I have on reply, of course I am. Lord, I have taken your losses the service rules that they wanted to say that this was not governed, no time scale or promotion in regard to the service rule. Lord, I have tried my best to say, Lord, the service rule which they have shown that was amended, but ultimately, Lord, this was there.
Yes.
And the second thing, I have taken your losses to the past history, how the time scale of promotion we have been enjoying from the very, at least the petitioners, from the very initiation of their service scale. Now, this is your losses. The third point I will be dealing with you before losses, that this was not a reference at all before the group of officers, whether the technical staff would be enjoying time scale of promotion. This was not a case of reference. That will be my last submission. If your office kindly take up page 39 of the 950 of the week, I will be on the very relevant portion of it. This is 13th January 2017. Now, this is office memorandum. Subject to your lordship will find pay revision of employees of quasi-government organizations, autonomous organizations, statutory bodies. The employees working in the quasi-government organizations.
This is finance memo.
Finance memo. Well, this will show you lordship what was the reference. Autonomous organizations, statutory authorities set up and funded or controlled by the central government are not central government employees. Therefore, the benefits implemented by the central government in respect of central government employees as part of their conditions are not directly applicable to the employees working in such autonomous organizations. But I tell you, losses the modus operandi of it. Whenever a revision of pay comes here, losses for the central government employees, it's not automatically given to these sort of organizations. What they do, your losses, by way of subsequent act, they grant it.
Yes.
These authorities place their cases before them, then the government. But at no point of time that benefit would be better than this government.
Yes.
That's the bone of contention. The application of such benefits as given to central government of employees in respect of employees of such autonomous organizations, as well as the manner and conditions governing such application, including sharing the additional financial implications arising thereon, requires specific approval of the central government. The autonomous organizations are expected to manage their affairs in such a fashion that dependence on the central government for financial support to meet the extra financial implication is minimal, such as autonomous organizations are expected to be financially self-sufficient, so as to not cause extra burden on this central exchequer. Then your losses kindly consider the next paragraph, last few lines. It has been decided that the revised pay scale as per the pay matrix as contained in Part A of the schedule of CCS RP Rules 2016, as well as the principle of pay fixation as contained in the said rules, may be extended to the employees of such organizations. That means all the funded organizations, subject to the following stipulations. The conditions of service of employees of those organizations, especially those relating to hours of work, payment of OTA, overtime allowance, are exactly similar to those in case of central government employees. Then your losses, the revised pay structure shall be admissible to those employees who opt for the same. 3. The deduction on account of Provident Fund, Contributory Provident Fund, National Pension Scheme may be applicable, will have to be made on the basis of revised pay with effect from such and such date. Then your lordships, kindly come to paragraph 4. This is to some extent relevant. In case of those categories of employees whose pattern of emolument structure, namely pay scales, allowance, conditions of service are not similar to those of the central government employees, a separate group of officers in respect of each of the autonomous bodies may be constituted in respect of the Ministry of Department. Now, therefore, what was the object, my lord? In respect of those employees whose pay and others are not similar to the central government.
Yes.
Their matters can be referred to the group of officers. From the very beginning, that we are the technical staff, we are getting similar benefits to that of the central government. So this was not the case, my lord, before the group of officers to be seen. However, then your lordships kindly see, the financial advisor of the respective ministry will represent the finance on this group.
Yes.
Then your lordships, the group would examine the proposals for revision of pay scales, taking into account the views, if any, expressed by the staff representatives of the concerned organization. It would be necessary to ensure that the financial package of the benefits proposed to be extended to the employees of those autonomous bodies, etc., are not more beneficial than that admissible to the corresponding categories of central government. What happened actually? We were enjoying time scale of promotion. This was on their own extended to the administrative staff, non-technical, by the Bose Institute, which was not being enjoyed by the central governments. Those cases will go before the group of officers, not our case. Now, any event, this was saying, I have to show your lordships that we satisfied them that we are not getting higher scale of pay or any higher benefits, except we are getting the same benefits of the technical staff of the other organizations of the center. Your lordships, my lord, with this kindly I will take your lordships to page 96 in respect of paragraph, and your lordships, then I will take the other paragraph. Your lordships kindly come to page 96 of the writ petition. Well, this is the meeting of the minutes of the meeting of the group of officers dated 24th June 2019. Well, your lordships will find group of officers invitee from DST and the representative of the Bose Institute. Here, your lordships, the assistant registrar, director, all are present, even the one of the petition. Lord, I take your lordships to the paragraph 3A of this minutes. The representatives nominee placed the desired information as called by AI division that dated 14th June 2019 before the group of officers. On perusal of the furnished documents, the group of officers observed that the technical and administrative employees who of Bose Institute are having service conditions such as time scale promotion as per Bose Institute OA office memorandum dated 8/4/2018. Is it clear, dear lordships? Now, our case, we have been from the very beginning, 1997, thereafter Manos, your lordships, Kalra, we have been given. This has been extended wrongfully, rightly, I am not concerned, to the administrative staff. That's why whether they are enjoying higher pay scale of that administrative staff, the benefit than the higher benefit of the administrative central government, that is to be the lookout, not our case. Our case unnecessarily involved in the matter by the Bose Institute, being our employer. Now this is, my lord, now this was taken into consideration. From the content of OM dated such and such found that the order was issued to have pay and career advancement structure partly with that of the employees of the Indian Association of Cultivation Science, and the date of implementation of the order has been taken 22nd December 2005 as that of Indian Association of Cultivation of Science, Calcutta. After deliberating the furnished information, the group of officers observed in compliance with such and such memo and opined that it would be better to have the chronological events from Bose Institute, which led to adoption of timescale of promotion in lieu of vacancy-based promotion for its employees. Kindly see, which led to adoption of timescale of promotion in lieu of vacancy. We have never been the vacancy-based promotion, technical stuff. The documents related in origin of the Structural Reforms Committee, such as need for Structural Reform Committee, its constitution, its mandate, minutes of its meeting, final recommendation of SSC, its acceptance, approval, the reasons for bringing changes in the designee may be brought out. There was no change so far we are concerned. The difference in service conditions of the employees before and after 22nd 12/2015 may also be brought to in clear terms, including role and responsibility of post, pay structure, promotion, etc. Keeping in view and the duties of the responsibilities posted in Bose Institute with that of the corresponding pay scale, Bose Institute shall propose for the revised pay scale irrespective of post in 6 CPC and 7 CPC, along with detailed justification for consideration of group of officers. While making such proposal, it shall ensure that the final package of the benefits proposed for its employees shall not be more beneficial than the admissible to the corresponding categories of the central government. As per the department way office memorandum issued for that. So, according to it boils down whether we, technical staff, is getting more benefits than the corresponding counterpart of the central government employees or not. If we can satisfy the Honorable Court,
Yes.
the entire action of the authorities are in. Because we ought not to have brought it. In even, they have brought it. But I'm taking a point. This should not have been the reference. When you lawsuits the point, suppose your an advocate is the advocate commissioner. The court lays down that these are the reference. Can he go beyond that, your lawsuits? He can't. So this was not the benefit. It was not, no documents were shown that we are getting something more than the counterpart of the central government employees. This was not case. I am talking about before reference.
Yes.
After reference, I'm satisfying. That's another. But before reference, you have to satisfy that this was the case, you were getting more than that. The technical stuff. So your lordship, for better appreciation, mapping tabular, just now my learned friend probably test. Next, your lordship, can you come to page 84 of the petition. The first one, page 93, by which the group of officers was constituted. 13th January 2017, page 93. Now kindly see page 84. This is of 7th February 2019. As you may be aware, but before that I took your lordship page 96 of one of the resolution of the group of officers. That's I have taken. But any event, kindly see that chronologically I am now showing to your lordships. As you may be aware, page 84 of the petition.
Yes.
As per DO expenditure 13th January 2017, page 93. It has been clarified that the categories of employees whose pattern of emolument structure, pay scale, allowances, conditions of service are not similar to those of the central government employees. A separate group of officers in respect of each of the autonomous bodies may be constituted in the respective ministry or department. Now, it is found that in some of the autonomous institutions of DST, the non-technical, kindly see your losses. We are not non-technical, we are technical. Non-technical / administrative staff are enjoying better conditions and promotionality. because of the act of the Bose Institute. They have given time scale of promotions, not vacancy based. So we are enjoying that. So Malad, all that I'm trying to impress before the Honorable Court that this was could not have been an issue. You have jumbled up the issue. To satisfy someone, you have sought to bring me down. As advised by your finance, you are kindly requested to submit an undertaking duly signed by the registrar of the institute that only vacancy-based promotion is being granted to its non-technical and administrative employees. So, my lord, whatever could have been submitted by the Bose Institute was in respect of non-technical and administrative staff, not in respect of technical staff. It has also been further suggested to withhold the 7 CPC benefits to non-technical and administrative staff till the group of officers recommends the case.
Yes.
Well, therefore, my lord, if you listen, we read together page 93 and 84. It is clear, my lord, what was the reference. They went beyond the reference. Then your lordship, can you see page 86? I will be taking your lordships 86, my lord, 87, that your lordships will be the second resolution of the group of officers. If I'm not wrong, your lordships. I will be on, my lord, it starts at page 87. No, this is Bose Institute Finance Committee, my lord, page 87. This is a, my lord, Finance Committee resolution of dated 28th February 2019. My lord, if your lordships, straightway come to page 89, miscellaneous.
Yes.
Director officiating, Bose Institute opined that DO letter dated 7th February 2019, that's your lordship, page 84, just now I placed, has been received from the Department of Science and Technology, Government of India, asking for a declaration from the Registrar Bose Institute that only vacancy-based promotions are being followed for non-technical and administrative staff of the institute. The ministry has further advised to withhold 7 pay commission benefits to non-technical and administrative staff where vacancy-based promotion are not followed. The chairman stressed to strictly follow the Government of India rules and regulation in this respect and the instruction given by the Department of Science and Technology. But kindly consider this, whether I'm rightly taking your losses to the point. This was the case only the vacancy-based promotion. If you do not follow up, then don't extend the benefit, even you have extended all till group of officers decided in respect of administrative staff. They have brought us unnecessarily within the domain of the group of officers. Then your losses kindly consider page 85. Malad, I think, Malad, if the person's sitting on the same, beneath the same roof and wants to teach someone, it's very difficult. Because ultimately, someone wants to teach me, that's my officer. That's my officer. If I'm allowed, suppose I'm working with my junior, he's as good as a learned advocate. If I want to teach him, well, that's very not obnoxious situation. I have placed before your lordship page 84, 7th February 2019. What was the scope? Now kindly see this Noren Bhattacharya, what did. This is after 7th February 2019, 22nd February 2019. As per the provision of 7 CB such and reference to 7th February 2019, Bose Institute being an autonomous institute under the Department of Science and such has to adhere to the rule position in respect of service matters of employee. Now he is doing all employees. Can you have a look at this? How he is extending it and bringing it to the domain. Accordingly, service condition of all non-academic staff members, including technical staff, cannot be better. But what authority he had or she had? Kindly, I request your lordship, kindly go through your lordships one by page 84 and 85. Does it go? Is it not contrary, entirely contrary to page 84 of the Department of Science and Technology? Does it say bring technical staff? And then in view of the above, the competent authority of the institute has decided that the service condition promotion of all non-academic staff. You are making jugglery of words. I am certainly not on academic staff. I am certainly non-academic staff, but under non-academic staff, I am a technical staff, not administrative, not purely technical, non-technical. I am absolutely technical staff. But this has created the entire thing. This is entirely contrary to the page 93, the initial memo constituting group of officers, and the DST's memo. I have taken your lordship on the last occasions, the history of the entire technical staff, how they get the time scale of promotion. That was recorded in the minutes of the post institute.
Yes.
Now, this is the situation for which we are now suffering. Now, your lordships kindly see page 112 of the impugned order. Well, this is 16th February, October 2019. I am directed to refer to your letter on the subject noted and such, your lordships. 13th January 2017, parent memo, and then 5th March 2019. A group of officers were constituted in respect of the Bose Institute with the terms of reference to examine the pay packages of the Bose Institute, taking into account the views expressed by the staff representative, and ensure the final package of the benefits extended to the employees of the institute is not more beneficial than that admissible to the corresponding categories of the central government employees. Now, what was the issue? Apart from also what I have submitted, that you have to see whether technical staff is getting more beneficial benefits than the counterpart of central government or not, at best.
Yes.
Irrespective of the reference, beyond the scope of the reference. The final package recommended by the government of India, group of officers, will be submitted to ASFA for further. The group of officers in respect of Bose Institute held a meeting on 24 June 2019. After a detailed deliberation and duly taking into account all facts and documents recorded, the group of officers has found that the employees of BI are presently in receipt of pay and allowances at a higher rate than admissible to the corresponding categories of the central government here. Pause here for it. You have just given a generic term, all employees. You mentioned it, technical, non-technical, administrative. Why don't you do that? Just to affect someone's interest, which you was enjoying. You ought to have mentioned what was my benefit. You deal with that. I will take your lordships to the group of officers report. With view to contain overpayment on this account at the earliest, the group of officers has recommended several remedial steps for restoring the pay and allowances to their original position as on 21st December 2005. But can it be done, even if your lordships suppose it has been done? Can it be done like this? With your eyes closed, you have done it for a decade, more than a decade. And grant of telescopic and retrospective fixation and disbursement as per 6th pay commission and 7th pay commission. The competent authority has considered the recommendation of the GO, decided as follows. The order issued on such and such were illegal, arbitrary, and without approval of the competent authority, and hence shall be null and void. But these were all pastel lawsuits. That these were in consultation with the representatives of the DST.
Yes.
The promotions and grant of higher pay scale above the norms of the government of India in respect of those categories of employees will be put on hold till such time the issue is examined and decision is taken by the competent authority. Bloody losses will not find any application of mine in respect of vacancy-based promotion or time scale promotion. Whether the time scale promotion for the technical staff is a more beneficial to the counterpart of the government employees. Central government employees or not. Why did the Malad my application of mine? I will take your losses to the group of officers. If they say Malad, probably they will say we have strictly followed whatever they have said.
Yes.
Now your losses, kindly see the next page. Roman 3. The designation, pay and allowances or other service conditions shall be restored back to its original position. 21st December 2005. There is a decision of the Supreme Court now that if there is no misrepresentation on the part of the employee, you cannot reset the entire thing. I have accrued rights. Some of them retired with this. Some of them is going to retire. Somebody might have 10, 15 or 5 years service left. You are dealing with this. And thereafter, replacement pay scale with grade pay of the corresponding post as per Government of India Order 6 CPC shall be granted with effect from 1st January 2007 respectively. And then your losses kindly consider 4, 5, 6, 7. The above, I'm placing only the relevant which affects the entire thing affects, but the relevant one. The above exercise, as you also got that. The above exercise for restoring the pay and allowances to their original position as on 21st December 2005 and grant of telescopic or retrospective fixation and disbursement as per 6 CPC and 7 CPC shall be completed within a month's time. The head of administration division, register of the head of the account, shall monitor and supervise on daily basis to complete the exercise and send details to the DH. Then your losses can come to the next. Last but one paragraph.
Yes.
In addition to the above, issuing of illegal and arbitrary orders by the boss in the I couldn't follow rules and regulatories of the government in contravention of whatever, and thereby causing huge financial loss to the government exchequer have been viewed serious. The 7 CPC benefits have been granted to the employees of BI by suppressing, but all saying employees. They never say technical, all that. Furnishing false declaration. Take note of this. I will deal with this. Suppressing facts and furnishing false declaration that the service terms and conditions of the employees are identical to corresponding employees. I will show that so for technical employees, there was no false declaration. This may be in respect of administrative staff, non-technical staff of the central government. Necessary action for fixing responsibility in initial proceedings may therefore be initiated.
Yes.
And then your losses, page 116. These are the 2 impugned orders. This is of 4th December 2019. In furtherance to this office such and such, letters issued to individual staff based on the office circular in consequence of letter dated such and such 16th October 2019, as I just now placed before lawsuit. The undersigned is instructed to inform all non-academic staff, both administrative and technical. Kindly see, Malad, how they deal with the situation. That though the competent authority both is continuing with the payment of salary and pension as per 7 CPC, till date, excess payment made, if any, to the non-academic staff, both administrative and technical, including pensioners, non-academic staff, due to continue, will be recovered, even after retirement. Now, Malad, this language they are using, Malad, non-academic staff, and then bringing the technical staff. Now, that's why I have taken your losses to all these memos. Now, I take your losses to page 79 of the application.
Canter.
Lord, application can 3 to 6. Now you'll also page 79, paragraph 3. The terms and references.
Can 3.
Can page 79. This is the report of the group of officers. Well, this is also, I'm told, Malati, I can't read it. At the top, Malat handwritten is draft report. And legible to a lot of
Yes.
draft report. Now I will show why this is draft, that ultimately. Now kindly see the first paragraph, this is very important. Department of Science and Technology in terms of DOE Office Memorandum, this is 13th January 2017, dated and dated such and such, has been constituted the group of officers in respect of those autonomous bodies where the non-technical or administrative employees. Kindly see that term of the consensus, who are enjoying promotion avenues better than the central. So we were not within the scope. I'm sorry, Malad, I'm harping on repeated. This was not the terms of reference. They mention it. Now see how they proceed with this. Paragraph 3. The terms of reference of the group of officers was examined the pay packages of the respective autonomous bodies. Malad, autonomous body may have a pay package, but in respect of its employees, you should mention what are the employees. Who are the employees? I'm saying you are making it vague. At the top, you are mentioning non-technical and administrative. But when you started dealing with that, you just oblivious of the fact this is confined only to non-technical and administrative. Taking into account the views expressed by the staff representative and ensure the 7th CPC final package benefits extended to the employees of those organizations is not more beneficial than that admissible to the corresponding categories of the central government. Now, this is entirely contrary to your losses, the 13th January 2017 and page 84 of the petition of DSP itself by this group of officers. They have traveled beyond their authority and scope. Now, terms of reference gives them the authority. They do not derive any authority under the law. So this report is absolutely contrary to the terms of reference and illegal. Now your losses kindly, I take your losses to the relevant portions of it. Now your losses kindly come to page 81. Table showing the post column number 18, serial number are in the losses.
Yes.
Table showing the post pay scales, residency period, respective job responsibilities of various posts in both institute vis-a-vis DRDO. This was placed by the Bose Institute. Of course, our representatives were there in respect of comparison to show that the technical staff are getting not any more beneficial benefit than DRDO counterpart of technical staff. This meeting we didn't, but your lordships, when we submitted our mapping, that was your lordships, we signed it, some of us. Two representatives and the director and the registrar, that mapping. Here your lordships, what I am showing to your lordships further, most important. Kindly see, my lord, para 3. In addition to the submission made by both institutes, the group of officers thought it prudent to consider as to whether such adoption of timescale of promotion in respect of non-academic and technical staff in lieu of vacancy-based promotion with effect from 2005 by its such and such was implemented with the approval of the competent authority as controlled. But was it the reference? Kindly see how they bring us within the domain. This was not within reference, but I'm not trying to deal with this. I will deal with it.
Yes.
That I have to show that I was not getting any more beneficial benefit than the counterpart of this and the here, I have given an example here. How they deal with that's not malafide. From the documents and records made available to the group of officers, the contention of Bose Institute that having reliance on DST earlier memo 79 the governing council had accorded approval of pay parity or non-academic staff of PI with that of the ISC is found factually incorrect. Well, see. From the documents and records made available, the contention of both institutes that having reliance on such and such, the governing council of PML have accorded approval of pay parity of non-academic staff of both institute with that of ISE with effect from 2000 is found to be factually incorrect. Malad, here two contention malad arises. First, your lordships, you have to see that whether technical staff, I am on technical staff,
Yes.
were drawing more beneficial benefit, more higher benefit than counterpart or not. Other thing, your lordships, whether this GST approval or not. Suppose, your lordships, I am not drawing more beneficial, I am drawing equal to that of the DO. Malad, absence of any malad DRT approval, express approval, malad, does it amount malad, or give them authority to take away my benefit, which I am enjoying since my service career? With the approval, I have taken, your lordship, extenso. All the minutes, all the DST representative pending. I have given the history, what was recorded, your lordship, how this has been given to us from our service career initially. We have joined 97, 98 onwards.
Yes.
Since we have been getting. So, malad, first they have to show, malad, see whether we are technical staff was drawing time scale of promotion contrary to the benefits given to the technical staff of the government or not. That was the malad bone of contention, malad, the reference to the authority. The chairman agreed that there should be parity between IACS and both institute in terms of the pay structure of other benefit staff as indicated. But pause here for a moment. We showed the instances of DRDO. Why don't you deal with that? That's directly, Indian Science of Cultivated Science is another institute like me almost. Funded institution. That's also Society and Society Resistance Act. Issue before was that whether technical staff now. That was not an issue. You are dealing with that I'm saying. I'm getting more beneficial pay benefits than the or promotional benefits than of the counterpart of the central government, DRDO. Why don't you deal with that? You are dealing with ICSC. You are going to the back. Then Professor M.G.K. Menon, the then Secretary of Government of India, in his capacity as Secretary of DST, informed the council that not only should there be a parity between ISS and both, but among all autonomous institutes of the Ministry of Science and Technology. He assured that the council had some, but they're extending the entire thing issue. This was not an issue. I have taken your page 83 and 84, 93 and 84. Now, this was not an issue before that. Then your lordship kindly see. Meanwhile, paragraph 16. On 8 April 2018, both institute authorities, without received any approval from DST on the subject matter, proceeded on the issuance of 8 April 2008 on its own. The first para of both institute poem itself states this fact is as under. I will take your lordships to this paragraph itself at page 76 of the read petition. Lordships, kindly keep it open with the paragraph 76. This is 8 April 2008.
Yes.
In terms of reference of the office memorandum dated 8/8/1979, the government of India raised with such and such in accordance with such and such. And after 5 lines, in anticipation of the formal approval regarding parity between the post institute and similar other DST institute, government of India, the director board having been satisfied that the revised pay structure and career advancement scheme was implemented in Indian Association of Cultivation of Science with effect from 22nd December 2005. Well, pause here for a moment. CAS, we were not entitled to because we have a different promotional channel. Right from the beginning, I have placed it. And on the recommendation in the meeting of the chairman heads of the department section held on 8th April, has displeased to order to implement the identical revised pay structure scheme of IACS for non-academic staff, both technical and non-technical, of this provisionally that is the same date of 22nd December 2003, for keeping parity between both institutions and ICS subject to the conditions that overpayment if made, thereby consequent to otherwise decisions by the company shall be recovered. Malab, there was no overpayment. If you say that this was grant is illegal, that's one aspect. But you do not consider whether being a technical staff, I was drawing anything more.
Yes.
I was not drawing anything more. I was in the time scale of promotion. Your losses on this account, your losses, your losses can be take note of. GFR, learned friend Mr. Chakraborty handed over to your losses. A bunch of rules. Rule 230. এরকম দেখ
আচ্ছা আচ্ছা তারপর
এটা কি হ্যাঁ the very next page, rule 230, 12 within bracket I, Roman. Page will be handwritten 19 and then 20.
Rule 230.
All guarantee institutions or organizations will receive more than 50% of their recurring expenditure in the form of grants in aid should ordinarily formulate terms and conditions of service of their employees which are by and large not higher than those applicable to similar category. What is that finding? Any of the in the order, could you also finding the technical staff were getting higher benefits than of the counterpart of the year? That's the issue, man. This was not an issue. I could not have done an issue before the group of officers, but you have brought me. Now then decide is the appropriate. You do not deal with my case. Now I take your losses. Again, page 82 of the application I was placing. This 8th April I have placed before a lawsuit.
petition.
Yes.
Now your losses can be page 83. Report, this is one of the operative portion. Paragraph 20. After perusal of documents and records made available to the group of officers, we are of the opinion that office memorandum dated 8th April 2008. Just now I placed it to losses. Page
Yes.
7. Paragraph 20. Has losses got the point? After perusal of documents and records made available to the group of officers, we are of the opinion that the office memorandum dated 8th April 2008 and office memorandum dated 5th April 2008 by both institutes is void ab initio, being issued without the approval of the competent authority. That was it an issue? Now suppose without giving any authority. Ultimate issue was, but in respect of all I am subject. Forget about technical, non-technical. I am on the for technical stuff. Is it your finding that they were getting higher benefits? Where is that? Without approval, without prior approval. This was not an issue. Whether I am getting higher benefits than counterpart of the government of India or not, that was an issue. And that's the your finance rules. No executive rules, any event you're lost. So this was not the decision. Then your losses kindly see, considering the fact the following recommendations are made. I take your lordship to Roman 6. Kindly see. Promotion would be granted on arising of vacancy. Now, cat out of pocket. This was our intention to curtail this my time scale of promotion. That's why you have brought me under this. Where is your finding? I'm repeating your lordship. At the cost of repetition, I'm doing it. Where is your finding that this time scale of promotion enjoyed by the technical staff of both institutes is more beneficial than the technical staff of the RT or any other government authority or in department? Where is that? This is not your finding. And this was the case before the group of officers. They are avoided to deal with it. Because if they deal with it, they have to say, no, this is not, this is similar. This is Malad, the things Malad pinching us your lordship. Now, kindly see the Malad, then your lordship, let me proceed further. As being followed earlier in VI. Assured promotion scheme, modified assured promotion scheme as applicable in Government of India from time to time shall be applied to administrative and technical staff. Kindly see. This was never applied to, right from Kalra, Manos, your lordship, following. I have 7 your lordship there with the approval. Now they are withdrawing. So this was not an issue. What is the finding that the technical staff in the Government of India, department and other wing is not getting time scale of promotion, but you are getting?
Or getting more
Exactly.
benefit.
What is that? Why are you doing it? You have not been formed for this. Then you lost 8. The employees of both are presently in receipt of pay and allowances that had it and with the intention to contain the overpayment. Had it, but how? Because if they say your lordship that finding without approval. Now I say your lordship, this is in respect of pay, not time scale of promotion. Now if you say this is without approval, one thing, and if you say this is more beneficial, that's another thing. But if you say without approval, therefore more beneficial, well, I'm getting 3 things.
Yes.
That's one thing. First one thing, straightway I'm getting more beneficial. I'm not entitled. Second thing, I'm getting beneficial, more beneficial without approval. That is another thing that I'm not getting. Third thing you are saying, you are getting the benefit which is without approval, therefore more beneficial. That's it. This is not your effort. You have to see only whether I am getting 2 rupees, whereas my counterpart getting 1 rupees only. More, other than this was not your reference. I'm allowed on reference. You don't have that because the authorities are acting on that. Now your lordship will find my lord, page 84. Then your lordship 85. Now your lordship kindly come. Page 85, your lordship will find. Well, your lordship will not find the signature of director of postings. He is the convener of the meeting of the postings. This is the document under the RTI. That's why your lordship at the front page draft report. Did they act on draft report? Then entire thing falls. He is the convener, but he has not signed it. I don't know. Call for the DECO documents of the original report. We are not at all present. We only submitted our documents report. This was not signed. The lawsuit will not find it. The draft report, that's why. If they acted on the draft report, then entire things would be. Now I take your lawsuit to last thing I will point out. Kindly take up our affidavit in reply to the respondent numbers 1, 2, 3, and 4.
Yes.
Now, Malak, whatever submitted by the Bose Institute on our behalf, well, of course, To that, we documents we have signed and we prepared to show that we are not getting any benefit more than the counterpart of the central government technical staff. Well, we get it, my lord, after submission under the Right to Information Act. It starts from page 40.
Mr. Sanal, I have some fixed matter today, 12:30. Some partner matter is going on.
Next day I will come. Yes.
Well, with regard to item number 56, 156, that is the very next matter regarding Bose Institute. My lord, can it be our matter on 9th, that is after reopening, 9 January? Because we have not started yet.
Yes.
As my lord has stated the workings, how the matter will be proceeded. So what I am seeking is that can it be on 9th so that Mr. Chanal will complete. Mr. Bandyopadhyay I also believe will complete. So 9th will be the safest days for us to start and try to conclude on that day. 9 January.
This matter will be fixed on 9.
154.
Yes.
Oh, and then it won't be on 9th. 19th.
9th of January.
9 January.
9th of January.
19th in between, Lordship.
Because next Thursday is there.
19th, this code would not be functioning.
Oh, I'm grateful, madam. I'm
Okay.
grateful.
Please take down argument on behalf of the petition, argument on reply on behalf of the petitioner. Hard in part. Let the matter appear in the list on 9th of January. Under the same heading.
9th January.
9th of January.
Much obliged.
দেখানো হয়ে গেছে তুমি কিছু বলবে?
না আমি তোর জাজমেন্টটা তোর জাজমেন্টটা তুই কালকে দিতে দে।
তুই বলে দাও।
তুই বল তারপর
আবার বলে
হ্যাঁ তোর বলা তো
আমার বলে
আমি রিপ্লাই দেবো।
এইটা কি হচ্ছে? আমি কি দিচ্ছি?
অপোজিশন দিচ্ছি আবার তুমি করে আমি শুধু তোর জাজমেন্টটাই দেবো।
আছে তো আছে।
হ্যাঁ আছে আছে। এই ওই ছিল
Yes.
The Milord,
My learned friend had cited a few decisions in reply,
Yes.
for which, my lord, I get another opportunity to address your lordship on this matter. Now, I had raised an objection that an association cannot be a person aggrieved. Therefore, my lord, my learned friend has cited 2014, volume 5, Calcutta High Court Notes 277. Now, please take, my lord, this judgment. Well, this is a trade union which had moved the court. Now, the status of a trade union is not akin, I put it the other way now, the status of the writ petitioner over here is not akin to a trade union under the Trade Unions Act. Well, that is noted, my lord, in this judgment itself. Please have a look to, my lord, paragraph 13 of this judgment. But instead of reading the paragraph in its entirety, please take, my lord, page 284, where the last about 7 to 8 lines from the bottom of that page.
Yes.
My lord, the sentence starting with, it is only the locus of a trade union. My lord has found that. It is only the locus of a trade union and its right to file an application on behalf of its members that is to be considered. A trade union, it is now well settled, is a juristic entity recognized as a body corporate under section 13 of the Trade Unions Act. No similar provision, my lord, has been placed before, my lord, subject to correction, which makes this association, this Fair Price Shop Owners Association, as a juristic entity under some statute. This is the distinguishing feature. Because as your lordship knows, my lord, these trade unions
Yes.
but the trade unions are formed, they are registered only for the purpose of, my lord, taking up the cause of its members. My lord, they have a right to, my lord, negotiate with the employers. They have a right to bargain with the employers. They have a right to bargain with the other trade unions of the same organization, because in one establishment there may be 5 trade unions. So inter se between the trade unions, there can be again bargains, then, my lord, charter of demands, then settlements under the Industrial Disputes Act. These are all done, my lord, at the behest of the trade unions which are constituted. Now, kindly take the next sentence. It is entitled, that is the trade unions, under that act to take up cudgels on behalf of its members to redress their grievances by adopting legal means, including approaching the courts of law on behalf of its members. Now, these are statutory rights given to the trade unions. The administrative tribunal, I don't think the rest would be that important. Then kindly take the next page, or the last 2 lines of that page. There is no dispute that the government employees are entitled to form an union in order to ensure that any injustice done to them is rectified. A registered trade union is enjoined to protect the legal rights of its members. Therefore, a union must be considered to be a person aggrieved, so and so. Now, this is not the case over here. The association framed or formed over here does not have a statutory right or a statutory obligation, if I may put it in this way, to take up the cause of its members.
Yes.
But otherwise, it is there. I don't dispute that associations are formed usually for why? For what reason? To see that whoever is the part of that association, their rights, etc., are protected. But there should be a difference between an association formed for the purpose of doing some benefit, welfare, etc. of its members,
And trade.
and a trade union which has a statutory obligation. But I can give you a lordship an example. An association like this, the petitioner before my lord, they can come up with some, say, welfare program, some cultural activities throughout the year for its members, etc. But trade unions, they can do so, but that is not part of their statutory duty. Their part of statutory duty is negotiate on behalf of its members, and that is statutory in nature. Therefore, there is a gulf of difference between a trade union constituted and the rights and obligations of a trade union and any other union or association which are formed or registered under the, say, Societies Registration Act, etc. So this, my lord, this is my submission so far as the Calcutta judgment is concerned. Now, the other judgment which my learned friend has cited is 2016 volume 7, Supreme Court cases 703. Now, please have a look to this judgment. Para 34 of this judgment, 2016 volume 7 Supreme Court cases, a well-known judgment on Cellular Operators Association of India.
Yes.
Well, this judgment, the portion which my learned friend has placed, only reiterates or quotes previous judgment of the Supreme Court as to under which grounds a subordinate legislation can be challenged. That is what has been shown, which I believe is to be dealt with, Millard, at the final stage. Not at this stage, but still, since my learned friend has placed it, I'll make some submission on that. Please take, Millard, para 34.
Yes.
In so and so, the court, after adverting to the relevant case law on the subject, laid down the parameters of judicial review of subordinate legislation. Then para 15 of the other judgment is being quoted. There is a presumption in favor of constitutionality or validity of a subordinate legislation. This I have made my submission. And the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the grounds, following grounds. Now, kindly see the grounds. First is lack of legislative competence to make the subordinate legislation. That is not his case. He doesn't say that the state government has does not have the competence. Then B, violation of fundamental rights guaranteed under the Constitution of India. In my very respectful submission at this stage, where my learned friend is claiming some relief in the sense that no penal proceedings should be started against them or their members, that clause itself cannot amount to a violation of fundamental rights or natural justice. We have brought this natural justice concept to be at par with Article 14 of the Constitution, no doubt about that. But again, that prejudice test has to be the first criteria. Merely because there is a provision which seems to be somewhat violative of natural justice, ipso facto is not to be considered to be invalid. It is only when an infraction of natural justice results in prejudice, then and then only one can come up and put it to that extent that it is a fundamental right violation. At this stage, there is no scope. Then then C is violation of any provision of the Constitution of India. I don't think he has made out that case subject to correction by my lord. Then failure to conform to the statute under which it is made or exceeding the limits of the authority conferred by the enabling statute. Milord, kindly recollect, Milord, the bone of contention is that it is not akin to or in tandem with the central control order. Therefore, this part or the D part, failure to conform to the statute, in my very humble submission, again will not apply. But again, these are all to be considered at the final stage. Then kindly take E, repugnancy to the laws of the land, no question. That argument has also not been made. Then manifest arbitrariness, unreasonableness to an extent where the court might well say that the legislature never intended to give authority to make such rules. Therefore, manifest arbitrariness and unreasonableness is not any manifest unreasonableness. It is only manifest arbitrariness or the unreasonableness to the extent that when the court feels that legislature did not give authority to make the rules or competence. This manifest arbitrariness and unreasonableness is in connection with the competence.
Yes.
Yes, I have my right derived from Essential Commodities Act, which we call legislatively as a colorable legislation. Or in other words, F is colorable legislation. Then kindly take quoted paragraph 16. The court, considering the validity of a subordinate legislation, will have to consider the nature, object, and scheme of the enabling act, and also the area over which the power has been delegated under the act, and then decide whether the subordinate legislation conforms to the parent statute. Where a rule is directly, pausing here for a moment, here the parent statute is not the central control order, from which some distinctions are being drawn. Here the parent statute is my Essential Commodities Act. Where a rule is directly inconsistent with the mandatory provision of the statute, then of course the task of the court is simple and easy. If a provision is shown from the statute and said that this control order is directly in conflict with section X of the Essential Commodities Act, the job of the court is said to be simple and easy. Kindly take the next sentence. But where the contention is that the inconsistency or non-conformity of the rule is not in reference to any specific provision of the Enabling Act, but with the object and scheme of the parent act, the court should proceed with caution before declaring invalidity.
Yes.
Therefore, my lord, my respectful submission is, going by the quoted paragraph 16, is that if some provision of the Essential Commodities Act was displayed before your lordship, and referring to that, if it was shown that the Bengal Control Order paragraphs X, Y, and Z are in direct conflict with that, then and then only, my lord, it can be done. Otherwise, it's very difficult. Now, this is, my lord, the confines or the challenge to a subordinate legislation is concerned. Page 26. But kindly have a look to the other judgment which my learned friend has cited, which is reported in 2064 SCC 517. Download করলাম না কেন? Now kindly see paragraph 4. Here the cause of action was stoppage of quarrying, sand quarrying. But paragraph 4, please take the last 4 lines. With effect from 2/10/2003, the state government stopped all these sand quarrying by private agencies, several writ petitions were filed, etc. Therefore, this was a case where the state had taken some action. Obviously, that gives rise to a cause of action. When my fundamental submission was framing of a law is no cause of action. Applying the law adversely to the interest of a person may give rise to a cause of action for moving the court, and also for praying for a declaration that such and such law is bad because of so and so reason. Therefore, Miller, this 2004 judgment, judgment in my very respectful submission would also not apply. And I'm told me my learned friend has given an example that when my lord was sitting in the last vacation, Miller, this condition was applied and certain adverse steps were taken to which the person concerned had applied before the court. Association couldn't have come. That is why the person who was affected or aggrieved by my action under this particular rule, of which today stay is sought for, he has come and espoused his own cause. Association cannot come if it pinches one of its members. Therefore, the member himself has to come and espouse his cause. And I don't think I need to trouble your lordship much, except that kindly look into the provision once more. This is at page 60. 60. 70. Now, this is part of the central control order. No appeal. But kindly take, my lord, a similar language from the central control order. Page 74, kindly have a look. This is in connection with appeal. If at all this is relevant, just only to draw your lordship's attention, 10.4, which is the appeal provision, again of the central control order, uses identical expressions: no appeal shall be disposed of unless the aggrieved person has been given a reasonable opportunity of being heard. Now, when the question of reasonable opportunity of being heard comes, it includes everything. The only distinguishing feature which my learned friend can argue is, at the appeal stage, he knows the charges. At the most, he can say so.
44, 45, 46.
Now, kindly take, Miller, page 103, 102.
Under the impression my learned friend should only consider the judgments. He's opening the case again.
No, I'm not opening the case.
Re-argue.
You have re-argued once. That is why I got a chance.
I argued once.
Because I don't have a right of reply to a reply, yes, sir. Anyway, I don't trouble your lordship with that, since my learned friend is not comfortable with that. I stop here. But my lord, these judgments, in fact, supports my points of demur which I have taken at the first instance. Yes. Yes. Where individual gets aggrieved, they come to court, your lordships considers the merit of the matter, passes orders. But not at the instance of an association. You know, these are my submissions. আবার কি রিপ্লাই টু রিপ্লাই আমি তো নতুন কিছু বলি
আমি প্রথম দেখলাম যে পিটিশনার শেষ করে না মামলা, রেসপন্ডেন্ট মামলা শেষ করছে। But my learned friend has relied upon yesterday 2004 volume 2 Supreme Court cases, page 447.
ও আচ্ছা সেইটা
I sought for a time to distinguish the film. Page 447. ওটাই দেখাচ্ছি। But kindly come to page 447 first.
2004 two Supreme Court cases.
Page
447. Yes.
But it is a criminal appeal. Kindly first page. Criminal Procedure Code 1973. Power of court to award compensation to victims of offence. Held is not ancillary to other sentences, but it is additional there. Said power can be exercised. Judgment. At page 449 bottom. What is the cause of action? Page 449. The judgment starts. Justice
Yes.
Name of Justice Orijit Patra. What is the cause of action? An interesting question relating to the scope and ambit of section 357 of the Code of Criminal Procedure 1973, for short the code, is raised in the appeal which by order dated 15th October 2023 was limited to the question of grant of compensation, as was done by the High Court in view of the aforesaid, and the question of law involved, it is not necessary to go into the factual aspect. Next paragraph. The facts has been quoted. Now, Your Lordship, kindly come to paragraph 3. What happened in this case, my lord? In a criminal case, some persons have been acquitted and some person has been convicted. So far the acquittal is concerned, an appeal has been prepared. A compensation has been paid for. Court granted compensation directing the acquittal persons to make payment of rupees 30,000 each to the complainant. Whether this order can be passed ex parte or in presence of the person against whom the order has been passed. Kindly see paragraph 3. 3 lines. Dr. D.N. Singh, learned senior counsel,
Yes.
appearing for the appellant, submitted that the High Court has not kept in view the object underlying the grant of compensation under section 357 of the code. This criminal procedure code. This is a case where no fine was imposed by the trial court, but the High Court directed payment of compensation. While fixing the quantum, the accused person were not hurt, thereby violating principle of natural justice. An additional liability was fastened on the accused appellant, and therefore the principle of natural justice mandated grant of an opportunity. Court whether should hurt the party before passing any order. That was the consideration, not by the any statutory authority. Next, Your Lordship. Paragraph 5.
Yes.
Provision has been quoted. Provision of the criminal procedure code. Name. Kindly turn to my learned friend has read upon paragraph 10. Before that, Your Lordship, kindly come to paragraph 9. What was the consideration? That brings us to most crucial question, that is whether the court was required to hear the accused before fixing the quantum of compensation. It is urged by the learned counsel for the state that unlike a sentence of fine, before imposition of which court is required to be hear the accused. But that was the consideration by a court before passing any order of compensation. Accused person will be heard or not. And separate provisions of law under the Criminal Procedure Code has been dealt with. What ultimate conclusion? If there is no provision for providing opportunity of hearing, even court is required to give an opportunity of hearing. I fail to understand, my lord, so far our case is concerned, there is a provision for hearing. Entirely different. Our case is that question of issuance of show cause notice, submission of reply, handing over documents, copy of the complaint, copy of the report. Here a case which has been placed before Lordship in a provision of Criminal Procedure Code, there was no such provision to give opportunity of hearing before granting compensation, that has been considered. I don't think, my lord, so far our case is concerned, when there is already a hearing proceedings, this has any applicability.
Yes.
Then your lordship also come to paragraph 10, which has been placed before your lordship. Your lordship kindly come to paragraph 10 from bottom, line 12 line. Sentence start middle portion where the statute,
Yes.
which I've submitted just now, where the statute is silent about the observance of principle of natural justice. Can you take note of? Such statutory silence is taken to imply compliance with the principle of natural justice, where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by express word of statute, necessary indemnity. In aim is to secure justice or to prevent miscarriage of justice. Principle of natural justice do not supplement the law, but supplement it. These rules operate only in areas not covered by any law, validity made. They are means to an end of themselves, the principle of natural justice. So, but statute is silent at the time of passing order, whether any opportunity of hearing shall be provided to the complainant or not. Court says even then, an opportunity is required to be given. Our case is entirely different. This is not a case of compensation. Every judgment should be considered taking note of the facts of the case. A compensation cannot be equalized to a punishment of capital punishment of termination of license. Directing a person to make payment of compensation does not violate Article 14, 91G and 21 of the Constitution of India. We have made out a case, violation of fundamental right, for protection of our lawful business. Now my learned friend has also submitted something so far my judgments are concerned. Just I shall
reply. Judgment এর reply কর।
judgment people and reply করার
হয়তো তুমি আমার reply দিলে ওরও reply দিবে।
Just two or three lines. So far 2014 5 CH in Calcutta is concerned, my learned friend submitted registered association.
Yes.
And the trade union is not to be treated as equal. My association is also registered under the register of association.
No, it is argued that the trade union has some statutory liability and right. That was submitted.
Register of association has register of association to protect the right, interest, benefit of the of its members. Whether the cause of action of the writ petition does say that it is not protecting the service of my clients, members. I have shown to your lordship, possibly my lord, the supplementary affidavit has not been handed over to my learned friend, that already they have taken steps. The submission on the first occasion was before lordship that unless we are acting upon, so far the new control order is concerned, that cannot, no cause of action can be arose. It was also the submission that there is a provision for opportunity of hearing, which inbuilt gives other right also. But I have shown to your lordship from the supplementary affidavit, not even a show cause notice, not even hearing also. The last part of punishment of suspension, opportunity of hearing has not been provided also. And so far 2016 volume 7 SCC page 703 is concerned. My learned friend has submitted this point can only be considered as a final stage. So I admitted, my lord, that there is no preliminary objection regarding maintainability. When my learned friend is submitting before lordship, all these judgments shall be considered at the final stage of hearing, not at this stage. Meaning thereby, writ petition is maintainable.
No, I have made this submission that keep the point of maintainability open and direct filing of evidence. without interim
So
order.
these all, both these two judgments, my lord, 2016 and my lord, 2006, I have placed before your lordship only on the ground whether, my lord, the subordinate legislature can be challenged. The submission was subordinate legislature cannot be challenged. Both these judgment with no uncertain term says it can be challenged and interim order also can be passed.
Yes.
Now, just your lordship, kindly see our prayer. Need not go through the petition. I have made out the case on number of points. That is, my lord, inconsistency, violation of fundamental right. Ration card to be issued within a certain time. Reasonable number of cards to be tagged. Nothing is there. 45 years age bar. To distribute ration articles outside the shop room. Penal action, and that is not clear. Medical certificate from the registered doctors. Resignation as per whims of the authority. But today I am only praying for stay of operation of the order in respect of clause 45, page 102. That is penal action. I have made out a case of at least 13 points. I am not praying. I am only praying for penal action in respect of clause 45 of page 102 of the petition. These are my solutions. And Bhumijibi has been fallen from your lordship. The same issue, that is also not a trade union. So far the Bhumijibi judgment is concerned. Today I have not got that judgment, because I was not under impression.
Okay, please take down.
May I just come back one?
Yes. Petitioner number 1 is a registered recognized association of fair price shop owners all over the West Bengal and used to look after the right and interest and benefits of the members, of its members, who all have running fair price shop business all over the West Bengal. Full stop. Petitioner number 2 is the general secretary of petitioner number 1 and is a fair price shop owner. Full stop. Next para. The central government, in exercise of power conferred by Section 3 of Essential Commodities Act 1955, power conferred by Section 3 of the Essential Commodities Act 1955, promulgated targeted public distribution system within bracket control order 2015 VD order dated March 20th 2015 bracket shall be referred to as central control order hereinafter. Central control order 2015 hereinafter bracket close. Paragraph 9 of the said Central Control Order 2015 empowers the respective states to frame rules pertaining to the licensing of fair price shop dealer and distribution of essential commodities therefrom.
But may I take your lordship?
Yes, yes. In pursuant to the power conferred under the provisions of the Central Control Order 2015, read with section 3 and 5 of the Essential Commodities Act, state government promulgated West Bengal Targeted Public Distribution System within bracket Maintenance and Control Order 2024 within bracket shall be referred to as State Control Order 2024 hereinafter. It is the case of the petitioner that the State Control Order 2024 is a subordinate legislation which must be in conformity with State Control Order 2015. The it is the further case of the petitioner that different provisions of State Control Order is not in conformity with the Central Control Order 2015. Full stop. Among them, age bar of the applicant for having dealership license, comma, Duare ration scheme, comma, penal provisions, comma, and the definition of family and relatives are totally inconsistent with the Central Control Order 2015, and they are violative to the principle of natural justice reasons thereof. The instant writ petition was filed by the association for declaring the State Control Order, State Control Order, State Control Order 2015 to be ultra vires. Full stop. Mr. Sahara, learned counsel appearing on behalf of the petitioner, argued that the penal provision of the State Control Order 2024 enumerated in Chapter 9 giving an unfettered power to the authority to initiate a proceeding against the initiate and conclude a proceeding against a dealer without giving him any so cause notice or proper opportunity of being heard. Full stop. It is the positive case of the learned counsel for the petitioner that if the Chapter 9 of the Control Order 2024 is allowed to be continued, the member of the present petitioner, that is the dealer of the state of West Bengal, dealers of the state of West Bengal, shall suffer irreparable injuries. Thus, he prayed for an interim protection of stay in respect of Chapter 9 of the State Control Order 2024. Learned Advocate General, appearing on behalf of the state respondent, submits that the instant writ petition is not at all maintainable. The present petitioner number 1, being an association of dealers, cannot be termed as an aggrieved party. Full stop. He submits that the interest of registered association is in respect of its members and allied functions, but that does not give rise to power to the association, who is not an aggrieved party by enactment of penal provisions, to raise the issue before a writ court. It is a further submission of learned AG that the legislation has always a presumption of its validity. He further argued that if it is not proved that any provision of the control order is ex facie unconstitutional, the petitioner cannot entitle to any interim order. In support of its contention, learned AG has cited some decisions reported in Kusum Ingots, INGOTS, and Alloys Limited versus Union of India, reported in 2004, 6 SCC 254. 2 Jayashree Lakshman Rao Patil versus State of Maharashtra, within bracket 2021, 2 SCC 785. Kotak Mahindra Bank Limited versus MCD and others, 2008, SCC online 392. Arun Kumar Hathi versus State of West Bengal, 99 1999 SCC Online, Cal 130. And Mangilal, MNGILL versus State of MP within bracket 2004 to SCC 447. Refuting the contention of the learned counsels for the learned AG, refuting the contention of learned AG, Mr. Saharai has also placed some authorities. They are DND Homeopathy Medical College and Hospital, Employees Union versus State of West Bengal. Reported in 2014, 4 CHN Cal 277. Article 2 Cellular Operators Association of India and others versus Telecom Regulatory Authorities of India and others. Within bracket 2016, 7 SCC 703. Third, State of Tamil Nadu and another versus Pre Krishnamurti and others. Also, the learned councils as well as the learned AG has clarified the law of the respective judgments declared by the Honorable Apex Court and also contradicted the observations are not at par with the propositions of law as required to be dealt with in this matter. It appears that the respondent, it appears that the learned AG has challenged the maintainability of this writ petition on the ground that the petitioner number 1 being a registered association of dealers cannot maintain a writ petition before before this court. It is the positive assertion of the learned AG that the association itself cannot said to be person aggrieved. It is the positive argument of learned AG that the observation of Honorable Division Bench of this court in DN Homeopathic Medical College and Hospital is in respect of trade unions and their right to maintain a writ petition. Full stop. He submits that the right of trade union is a statutory right to confront the right of its members, but such statutory right is not available with the present petition number 1. Mr. Saharai has argued that the promulgation of State Control Order 2024 is itself violative to the principle of natural justice. Itself violative to the principle of natural justice. The association, the petitioner number 1 is a registered association of dealers. The association is formed to look into the interest of its member the dealers being the member of petitioner number 1, their interest can be very well looked after by the petitioner number 1, can be very well looked after by petitioner number 1. In considering the argument of the parties, it appears to me that the point of maintainability as raised by the learned AG before this court can be dealt with at the time of final hearing of the writ petition. Let the matter be kept open. Whether the instant petitioner number 1 has the authority or locus to file the writ petition on behalf of the members, on behalf of its members, for the dealers, can only be considered after thorough deliberation of the documents. Full stop. In considering the interim prayer of interim protection, it appears to me that the chapter 9 of the Control Order 2024 giving the power to the concerned authority to initiate a criminal proceeding, initiate a penal proceeding against a dealer without serving him any show cause notice. Moreover, the provision is not clear how the affected dealer, how the affected dealer shall attend before the authority without being informed about his offense. The provision also not made to serving a copy of complaint before the date of hearing. Thus, a dealer shall appear before the authority on the date of hearing without knowing the allegation against him. Considering the aspect, I think it necessary this provision shall give the unfettered power to the hands of the government officials, by which the dealers right to remedy or right to hearing, right to proper hearing would be violated. In this case, it appears that there are prima facie reasons to hold that if the chapter 9 of the State Control Order 2024 is allowed to be continued, the dealers shall suffer irreparable injury which shall not be compensated in terms of any money. Under the above provision, I think it necessary to issue an interim order in respect of chapter 9 of State Control Order 2024. Hence, it is ordered that the chapter 9 of West Bengal Targeted Public Distribution System Maintenance Control Order 2024 and its operation thereof be stayed till 8 weeks from date, the authority concerned shall proceed with the penal provisions as enumerated in the central control order in the meantime. The state authority is that state respondents are relieved to file affidavit in opposition against the writ petition within 3 weeks from the within 3 weeks after vacation. Exception if any, reply if any by the petitioner within 2 weeks thereafter. Let the matter appear in the list in the monthly list of February.
May I pay for a urgent photostat certified copy of
Yes, urgent photostat certificate copy.
Let's get rid of much of this.
Lordship, before rising only one.
I have a division bench there, that's why. Conclude the division bench thereafter. I have fixed the matter so that I can be dispose of this matter today.
Well, only thing for recapitulation, 5 minutes I want.
Okay.
Recapitulation,
Now,
then I will go to judgment.
your argument has been concluded, I think.
No. They are going to conclude, our argument started, I have to place the judgments.
Okay.
But before judgment, I'm just 5 minutes.
Okay. Proceed.
That's fine. Just for recapitulation. That my lot can be looked into page 36 of the petition. Just for refreshing it. 36, my lord. There are several charges.
Article of charges there. Thereafter, he was given punishment. Thereafter, he proceeded to the criminal court. Criminal court, he was acquitted, and now filed this writ petition.
Now, my lord, the charges were several charges are there under 36. I will show from the judgment of the criminal court. None of these first 5 charges are there. This is for irregularities committed in the bank. There is a falsifications, fraudulent activity in the bank. So these are different. So this is my lord, charges is 34. Then second, my lord, we have given him the documents. Whatever documents he required, given him, my lord, I have given the proceedings. I have given the proceedings before the inquiry authority that may be taken on record. I have already submitted, my lord. Now, my lord, they have satisfied themselves, accepted the documents, all documents served in the last part of my proceeding, which is submitted. Then, my lord, my
lord, kindly, my lord.
Let learned counsel finish.
My lord, only thing is, we have not admitted the documents as
Okay.
All documents have been proved by us by witness.
That I will show.
Anyway, my lord. And my lord, then the inquiry report was given. Inquiry report, my lord will find the bank had. Sorry, my lord. My lord, there are 4 witnesses in inquiry proceedings. That is at page number 58. But the criminal proceeding, about 21 witnesses are there. Same witnesses are not there. 2 witnesses are could be identified there. Page number 59. There are 4 witnesses examined before the disciplinary proceedings.
Four witnesses
of the prosecution side, of the bank side.
Of the prosecution side, bank side.
In domestic inquiry, examined. Whereas in the criminal case, about 21 witnesses were examined. Then, my lord, then as regards the documents that were served, all these stories, my lord, when he was charged or framed, inquiry was given to him, he made representations to the judgment, not a, he made a representation to the general manager, disciplinary authority. Nowhere there is any word, single word that he has not given all the documents. No representation is there. That is at page number 76. He never told that. If it was there, he could raise that issue. Then, my lord, no, that is, my lord, sorry, page number, I made a mistake. All right, my lord. That is page now, that same page number. What page number I told, my lord? That is page number 76.
That is the inquiry report. Page number 76 is the inquiry report.
General manager.
Annexure P12.
No, my lord. 76 P12.
P12.
That is he made a representation to the general manager on the inquiry report. Signed by K.K. Bhattacharya at page number 79.
Okay.
So he never, there he also, before the general manager, did not raise a single word, that the documents are not given or examined, etc. Page 76. Then my lord, appeal. Again, after that, my lord, disciplinary authority passed the order. That is page number 80, from 80 starts, my lord. Operative part of the order is 82. Operative part of the 82 starts from 80, my lord. Then, my lord, he filed an appeal before the appellate authority.
Yes.
To a chief general manager. That is at page number 83. It is a short representation by him with the appellate authority. He did not issue any word that he did not give in the documents. He is now raising that. Nowhere. He only said punishment can be reduced. That is page number 83, 84. In the appeal to the appellate authority, he did not raise as regards as regards documents.
Non-service of documents, right?
Then, my lord, he cannot raise now. Then, my lord, this appellate authority order is page 87. Detailed discussion is there about his submissions and the reply by the disciplinary authority and the appellate authority. All are quoted there. And this issue was not raised.
Yes.
This order starts from 87, ends at page 89. Nowhere.
Yes.
Then, my lord, this appellate authority order was passed in the year 2002. Disciplinary authority order is 2001. From 2002, he was sitting tight. Nothing done by him. So I have already submitted 3-4 decisions as the limitations. He cannot raise this point after 1.5 decade, more than 1.5 decade. Because he raised this point 2016 or 17, man.
Yes.
Now, 2002 is the last thing about the domestic inquiry, everything completed in 2002. Then, my lord, criminal court order. My lord, when look into the criminal court order, there, my lord, we have never lost any complaint before the criminal court, before the police. We have not. So here, my lord, order is, 1 second. This was from outside source. My lord, page number 92. Inside page 2 of the special court order.
Yes.
Paragraph 1st, 2nd, 3rd, 4th paragraph. We have not lost. We have not initiated the criminal case. Mr. Hazari, Inspector of Police, CBI, ACB, Kolkata, relying upon the source information, registered this case. So it is not at our instance. Now, my lord, charge. Charge is only after that two paragraphs only. It has nothing to do with my domestic information. Same and except certain bouncing of checks. There are about 10 charges. Out of the first five charges, the thing is there. So charges are not sent. What is the allegation against him? That is all in paragraph page 92, last paragraph and next paragraph. And these checks, this was issued but in other form, not fraudulent. This is one charge. So this is the point. Then, my lord, what is the observations because by passage of time, 2 decades, it is not a bank's case. In the case of the CBI or police, they do not produce documents, etc. Then automatically he got normally what happens? That actually happened. Now, as regards the witnesses 95, page 95, man, there are 29 witnesses. There were 29 witnesses. 2 witnesses are identical. There is one main witness, Somarkand, because he is not examined. Who was the manager at relevant time? He is not examined. Now, 2 witnesses are Mahadev Ghosh, PW4 and PW2. Only the domestic inquiry, these 2 witnesses examined, some of the witnesses examined, these 2 witnesses, they have also examined here. So all of the witnesses are different witnesses, not the same witnesses. So charges are different, witnesses are not same. Now, my lord, thereafter, what the special court said, my lord may come to page number. Wait, देखिए यहाँ पे लोग बोलो. These main criteria 2001, my lord, 3rd paragraph. For the purpose of constituting offense of cheating, the complaint is required to show that the accused, my lord, got it, page number 101. 101, 3rd paragraph. Criminal Code states, for the purpose of constituting an offense of cheating, the complaint is required to show that the accused had fraudulent or dishonest intention at the time of making promise or representation. Even in a case where the allegations are made regard to failure on the part of the accused to keep this promise, in absence of culpable intention, at the time of making initial promise, being absent, no offense under case. So this is the final criminal court with the ingredients of 420. But my case is irregularities in the form of granting the loan. Then, my lord, another observation. Another observation is there. 1 second. Loss, sustained loss. That time, sustained loss, I have not proved. That is not required to prove. So many advances granted. Whether we realize or not, I don't know one. Then, my lord, here. 1 line, my lord. My lord, page 113, 2nd paragraph. Special court observes like this. For the sake of argument, considering the evidence of PW10, PW18, and PW20, they were not my witness. They are their witness. At best, I may say that the accused one had committed an irregularity, and thereby forefinger can be raised against him that he was negligent in duty, and for that reason he can be departmental consequences from his department. So they also admit departmental thing and criminal thing are different. He can be held responsible for a negligent act. Lakhs of rupees have been granted. Yes. Then, my lord, but there is no evidence that the irregularity was committed or doing the illegal, and thereby cannot be said he died the illegal. So these observations there. Then, my lord, these are the things. Then ultimately acquitted, ultimately ordered. The accused person, one main accused was there. He already died. He couldn't be examined. Etc. was there inside. Offense punishable under section 120B, etc. hereby acquitted, and he was acquitted. So this judgment was passed sometimes in 2018, my lord. So after 16 years, criminal court, suo motu initiated one criminal proceedings, bank concerned, and ultimately found not committed, not guilty. And he wants to take advantage of that, whether even is found not guilty after 16 years, whether domestic inquiry can be reopened. Now, my lord, this is a judgment. Now, my lord, I will not I've taken much more than 5 minutes. This is the only thing. Now, in this background, I have already said, my lord, limitation point given 3 judgments. Main point limitation, my lord.
Yes.
That he cannot raise this issue, and he filed his writ case in 2017, and that too about 9-10 months after criminal court order. After criminal court order passed, after 9-10 months, he filed this writ petition. The writ petition was affirmed on January 2019.
2019.
Then page 30, end of it.
Yes.
And special court order passed in. Special court order passed in on 34/2018.
Yes.
So after several months, he filed this writ case. Raising an issue, he was acquitted from the criminal case by a criminal case. Raising an issue, there are similar charges. Raising an issue, the same witnesses. Nothing is there. No, this is all I think extra time I have taken, my lord. Now let me come to the judgments. Before dealing with the 2 judgments, one is Tara Singh, another is GM Tank, I will answer to the judgment. They do 2 judgments they submitted. My lord, I have submitted already AR 2015. They have submitted Tara Singh and GM Tank. That is their judgments. The GM Tank was already considered as subsequent Supreme Court judgments, etc. I'll place it, my lord. And factual as of Tara Singh, a completely different. That is their judgment. I will distinction or make later on, my lord. Let me place my version first. My lord, look into judgment of AR 2015. That is already there, my lord.
AR 2015.
Goodness account's case. What are the things each court can look into in respect of disciplinary and review actions that is specifically stated in para 13?
Yes.
My lord is fully aware of it. The recent past, my lord also passed a judgment on that. So I am not bothering, my lord, on that judgment. 2015 is there. Then, my lord, loss is not to be considered. I have given Bela Vakchi. That is also there. My lord also considered last judgment. Bela Vakchi, loss is not considered. Loss is not to be looked into. That is also, I am not wasting my honorable court's time, because on that judgment, my lord was considered in recent judgments. My lord's recent judgments. So these 2, I am not deciding. Then, my lord got it, the Bela Vakchi, my lord?
Bela Vakchi I have got.
Yes. Then, my lord, one judgment procedural given, but just for my refreshing only, that is judgment of Sanjeev Banerjee. Shiv Pujan Gwalia. I have given them also copy. Which? Hello, got it? Shiv Pujan Gwalia?
No. I have
those are limitations.
Arvind Kumar.
Those are limitations.
Limitations.
Those are limitation point.
On the limitation point, you have.
The limitation are already there. I know that. I have given it. I have argued in detail in limitation point.
Jai Kanwar, you have given PS Sadaswamy limitations. And you have given limitations.
Right hand corner.
MJ James.
There is a limit. It is not
on the limitation point.
It is not a limitation point. Those are limitation point.
Metropolitan water supply. TT Murli Babu.
These two. All limitation are already submitted. Now, my lord, I am placing another judgment. There is Shiv Pujan Gwalia. That is judgment passed by Honorable Justice Sanjeev Banerjee. As because all the time people are clamoring that making noise, the national justice is not violated. He specifically stated, my lord, that my lord, page 4, handwriting mark page 4. Page 4, third paragraph. The rule of natural justice has undergone considerable refinement, as it is no longer a mantra that can be chanted to escape the knots that a person may find himself to be tied in. He is saying document, we have not received the document, majesty violated, etc. That cannot be used like that. Loosely, we will say, but to prove it. Obligated judge চাইছেন? আচ্ছা. Next, my lord. There is another case, is unreported, I'm giving. Principles is let down, my lord. The Subhash Chandra Bor's case. দিচ্ছি আপনি কি দিইনি কাকে দিন এটা বলিস দিয়ে দিচ্ছি দিয়ে দিচ্ছি Subhash Chandra Bor, my lord. Paragraph 26, 28, relevant paragraph only, my lord, my mark. That is 26, 28, 29 to 31. What are these are all based on Supreme Court judgments. Paragraph 26, 28, and court had accepted that. These are my bank submissions. From 25 onwards, man. 25 onwards. Yes. 25, 26. 28, 29 to 31. These submissions were made on behalf of the bank and all were accepted by the court. The division bench of this High Court. Justice Ashok Kumar Banerjee and Samapti Chatterjee. Yes. So, my lord, then, my lord, criminal case and civil case both cannot go acquittal in the criminal case has no bearing on a domestic inquiry. My lord, I am placing Supreme Court 99. Then I will come down. It has to be reported. AR 99 Supreme Court লিখেন এই একটাই আছে আমি বলি বলতে দেন আমার আচ্ছা না আছে একটা যেটা অ্যাভেলেবল দিয়ে দেবো AR 99 Supreme Court. Page 6, my lord, lane. Paragraph 6. Paragraph 6. At the last part of the paragraph, middle part of it. In that case, court has rejected the contention that the disciplinary proceeding could not be continued in the face of the acquittal in the criminal case and held that the nature and scope of the criminal case are very different from those of the departmental disciplinary proceedings. And an order of acquittal, therefore, cannot conclude the departmental proceeding. This is so because in the criminal case, the charge has to be proved by a standard of proof beyond reasonable doubt. While departmental proceedings, the standard of proof of proving the KR charge is preponderance of probabilities. The tribunal was therefore in error in holding that view of the acquittal of the respondent by the criminal court on the charge relating to withdrawal out of visit. This system. So, same thing rewrite till today, my lord. 2022 judgment of the Supreme, my lord. Same thing. There is no change in the understanding of the Supreme Court. So this is the judgment 99. Then, my lord, I am coming to judgment of 2020. This is authored by the Dr. D.Y. Chandrachud, ex-Chief Justice of India. My lord, there is 2020 SC, নেই একটা দুটি আছে মুশকিল আমার খুঁজে পাবো না ফেরত দেবেন তো শিওর আচ্ছা this is a may I proceed, madam? My lord, may take this copy. This is judgment reported in 2020, SCC online, SC 886.
Paragraph.
Paragraph 60, paragraph 39, 40, 41 and 42 and 43. Paragraph 39. Kindly add paragraph. Let us start from, let us come from 16. 16 small 4 lines paragraph. 16, 39, 40, 41, 42 and 43. This is a relevant paragraph about the criminal case and civil case, and the end of it, when I'm coming to that, what is former court said. My lord, paragraph 13 I'm reading only. In exercising the judicial review in disciplinary matters, there are two ends of the spectrum. The first embodies a rule of restraint. The second defines when interference is permissible. The rule of restraint constricts the ambit of judicial review. This is for a valid reason. The determination of whether a misconduct has been committed lies primarily within the domain of the disciplinary authority. The judge does not assume the mental of the disciplinary authority, nor does the judge wear the hat of an employer. Difference of a finding of a fact by the disciplinary authority is a recognition of that idea, and that is that it is the employer who is responsible for the efficient conduct of their service. Disciplinary inquiries have to abide by the rules of natural justice, but they are not governed by strict rules of evidence which apply to judicial proceedings. The standard of proof is hence not the strict standard proof which governs a criminal trial. The proof beyond the reasonable doubt, but a civil standard governed by preponderance of probabilities. Within the rule of the preponderance, there are varying approaches based on context and subject. The first end of the spectrum is founded on difference and autonomy. Difference to the position of the disciplinary authority is a fact-finding authority, and autonomy of the employer is maintaining discipline, efficiency of the service. This is the main thing, man. I did not go further. An effect of an acquittal, paragraph 40. The present case, we have an acquittal of a criminal trial on a charge of murder. The judgment of Sessions Court is a reflection of vagaries of the administration of the criminal justice. The judgment contains a litany of hostile witnesses and the star witnesses resulting from the statements. Then, my lord, 37, acquittal is a criminal case is by itself cannot be ground for interfering with the order of the punishment imposed. This is a well-settled principle, though that the order of dismissal cannot be passed even if the delinquent official had been acquitted. It is now a settled principle law that order of dismissal can be passed even if the delinquent official had been acquitted of the criminal charge. This is a dissent judgment. No? Then, my most important paragraph 26. Paragraph 40. There is the end of it. Paragraph 39 is capturing. No, paragraph 41 is capturing some paragraphs of other decisions. There, my lord, page 26. 26 is there, my lord. Well, you got it, my lord. Last but one page. Before last but one page.
Yes.
Yes, my lord. As we have already indicated, in the absence of a provision in the service rules for reinstatement of an employee is honorably acquitted by a criminal court, no right is conferred on the employee to claim any benefit, including reinstatement. Very important paragraph. Service rule must capture that. That is acquitted, he must be reinstated. There is a recent decision of 2020 of the passed by. The judgment is authored by Dr. D.O. Chandrachud, ex-Chief Justice of India. This paragraph is very important. He's taken it from another judgment, but he maintained it. Paragraph 26, last page, before last page. I got it. So this is 2022 judgment, 20 judgment, my lord. Then, my lord, I'm coming to 22 judgment, another judgment 22. You miss. No, him sing. This him sing. There is another Umesh. ভাই এগুলো কিন্তু খুবই আমার দরকার, আমি দিয়ে দেবো, রেফারেন্স দিয়ে দিচ্ছি ভাই, লিখে নেন, লিখে দিয়ে দেবেন, আমার কাছে কপি হয়তো নাও থাকতে পারে। আচ্ছা, মেলড, there is another judgment, 2022 6 Supreme Court cases 50. This is Umesh. This is also authored by Dr. D.Y. Chandrachud. Yes. Paragraph 16, 17, 20, 21, 22. 16, 17, 20, 21, 22. Ashwin. Huh? Very good. আচ্ছা, 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 then my lord, 2022, Umesh, this is a judgment. কোথায় গেল উমেশ? জাজমেন্ট কোথায় গেল? ওগুলো দিয়ে দিলাম না। উমেশ হয়ে গেছে না? হয়নি, হেম সিং হয়েছে। উমেশ কোথায়? আপনাকে দিয়ে দিলাম, বলতেন তো জানটা বলা হয়নি। উমেশ, one second. Anyway, my lord, I'm giving this one copies with me. I'll give the reference. আপনি reference ঢুকে নেন, 2022 6 Supreme Court. Copy আপনি দিয়ে দেবো তাহলে। 2022 6 Supreme Court cases 563. 563 pages. Well, paragraphs are, my lord, yes, 20, 21, 22, and 23. I have one copy, my lord. That's
you have given the Umesh already. Did it?
Did you? Then, my lord, got it.
Paragraph 20.
Paragraph 20. He's referred some cases. We will come to the conclusions. Earlier Supreme Court judgments. There is Karnataka power transmissions. What is held, my lord, there? Then he referred the Nagarju case. See Nagarju's case. Then 22. Then conclusions. In exercise of the judicial review, the court does not act as an appellate forum over the findings of the disciplinary authority. The court does not reappreciate the evidences on the basis of which the finding of misconduct has been arrived at in the course of the disciplinary inquiry. I'm repeating it again, my lord. The court does not reappreciate the evidences on the basis of which finding of the misconduct has been arrived in the course of disciplinary inquiry. That is not to be looked into, my lord. Adequacy evidence, 50, 2015 judgment, my lord. We may refer to 2015 judgment. They are specifically stated. The court in exercise of judicial review must restrict its review to determine whether the rules of natural justice have been complied with. The finding of the misconduct is based on some evidence. The statutory rules governing the conduct of disciplinary inquiry have been observed, and where the findings of disciplinary authority suffer from perversity, and the penalty is disproportionate to the misconduct. Then by 2023, however, none of the tests for attracting the interference of the High Court were attracted in the present case. The Karnataka Administrative Tribunal, having exercised the power of judicial review, found no reason to interfere with the award, punishment, or compulsory retirement. The division bench of the High Court exceeded its jurisdiction. Division bench of the High Court exceeded jurisdictions under the Article 226 and changed upon a domain which falls within the disciplinary jurisdictions of the employer. The inquiry was conducted in accordance with the principles of natural justice. The findings of the inquiry officer and the disciplinary authority are sustainable with the reference to the evidences which was adduced during the inquiry. The acquittal responded in the course of the criminal trial did not impinge upon the authority of the disciplinary authority or the finding of the misconduct in the disciplinary proceeding. For the reasons we allow the appeals, set aside the impugned judgment of the High Court, Karnataka, this must be said. Yes. So this is the then my Karnataka called Karnataka transmissions. Yes, it has near from Bule Dawach. Bule Dawach, Monopuchana. No, it was Supreme Court. It was Supreme Court. Paragraph 5, 6, 7, 9, 10, 11, 13. One judgment more.
Yes, paragraph.
एक mistake हो गया. GM tank case was considered someone. Well, paragraph 5. They have given a judgment of GM tank's case. That is also distinguished here. Paragraph 5. Paul Anthony and GM tank's case both are distinguished. Six, 7.
Yes.
Earlier two judgments that the Mallam will find there, GM tank's case also distinguished there. Earlier judgments that give placed it. I missed it that time to refer it. Now remember. These judgments are distinguished. In GM tank's case, then when I will discuss, then I will say. Then my paragraph 10. The High Court set aside the order of dismissal on the basis of the judgments of the court of Captain Paul Anthony and GM tanks. Paragraph 10, madam.
Yes.
It is necessary to examine whether the said judgments are applicable to the facts of the case. Simultaneous continuation of departmental proceedings and proceedings in a criminal case on the same set of facts was the point considered by the court in Paul Anthony's case. The court was of the opinion that the departmental proceedings and the proceeding in a criminal case can proceed simultaneously. So this is not the issue, my lord. That is simultaneous. Then, my lord, GM tank's case possibly here. Paragraph 11. Reliance was placed by the High Court the judgment of the court of GM tank's case. Wherever the read petition was filed, the respondent was allowed. It said the case of delinquent officer was charged for an offence punishable under section 5.1, read with section 5.2 of the PC Act. He was honorably acquitted by the criminal court as the prosecution failed to prove the charge. Thereafter, a departmental inquiry was conducted and he was dismissed from the service. Here, departmental inquiry appeal was pending when the criminal court judgment was passed. In GM tank's case, there was brought to the notice of the appeal court. Appeal court did not take in consideration. Appeal before the departmental authority is pending. In GM tank's case,
yes.
Here appeal was pending. Then, my lord, there is the difference. Therefore, departmental inquiry was conducted. He was dismissed from the service. The order of dismissal inquiry upheld by the High Court. In the appeal filed by the delinquent officer, the court was the opinion that departmental proceedings in the criminal case were based on the identical similar set of facts. That is the case. The evidence before the criminal court and departmental proceedings being exactly the same, the court held that the acquittal of the employee by criminal court has to be given due weight by the disciplinary authority. On the basis of the evidence in both the criminal trial and the departmental inquiry are the same, the order of dismissal of the appellate therein was set aside. As stated earlier, the facts of the case are entirely different. The acquittal respondent number 1 was due to non-ability of an evidence before the criminal court. In my case, same thing. No evidence was brought in. The order of dismissal was based on the report of the inquiry officer, before whom there were ample evidence against the respondent 1. This is the distinction. So GM tank's case does not apply. Then, my lord, paragraph 13. Having considered the submission made on behalf of the appellant and respondent 1, we are of the view that interference with the order of dismissal by the High Court was unwarranted. It is settled law The acquittal by criminal court does not preclude the departmental inquiry against the delinquent officer. The disciplinary authority is not bound by the judgment of the criminal court. If the evidence that is produced in the departmental inquiry is different from the produced during the criminal trial, the object of departmental inquiry is to find out whether the delinquent is guilty of misconduct under the conduct rules for the purpose of determining whether he should be continued in service. The standard of proof in a departmental inquiry is not strictly based on the rules of evidence. The order of dismissal, which is based on the evidence before the inquiry officer, is a disciplinary proceeding, which is different from the evidence available in the criminal court, is justified, needed, and no intervention required. So this is they have distinguished GM Tank's case here also, my lord. Yes. Then, my lord, last Shankar Ghosh case, my lord. It kindly done. Here also GM Tank's case distinguished. This is reported in 2014. GM Tank's case 2006, my lord. There are enough water flowed in the Ganges. So many judgments came out. Shankar Ghosh case, item number 4, my lord, first page, GM Tank's case referred. It was, I had noted again, 2014, 3 Supreme Court. Dichi. Oh, very good. Actually, Bolini, Habishan Bolini. 10, paragraph 10, my lord. Learned counsel appearing for the respondent submitted the tribunal, the High Court have correctly applied the ratio laid down by the Poland's case and GM Tank's case and ordered in statement. The learned counsel also submitted that since the accused persons could not be identified in the TI parade, their complicity could not be established. Consequently, the capital it was held. We may at the very outset point out, then, my lord, last paragraph, let me come 14, my lord. Same thing they are repeating. We have gone through the judgment of the Sessions Court and the Supreme Court. This is thing. Paragraph 16, my lord. There, page number 615. Here, it must be in the service rules. Inspector General Police versus Seturaman, the court, paras 24, 25, 26 of judgment, has elaborately examined the meaning and scope of the honorable acquittal. Held as follows. As we have already indicated, in the absence of a provision in the service rules for reinstatement, if an employee is honorably acquitted by criminal court, no right is conferred on the employee to claim any benefit into the reinstatement. This was cited in the judgment, the court has accepted. It must be captured in the service rules. That if he is honorably acquitted, then he will not be held liable for the disciplinary proceedings. Then last paragraph, my lord, before 20. The above rule indicates that even if there is identity of charges leveled against the respondent, my lord, last before 20 paragraph, last. Yes. The above rule indicates that even if there is an identity of charges leveled against the respondent before the criminal court as well as before the inquiry officers, an order of discharge acquittal of a police officer by criminal court shall not be a bar to the award of departmental punishment. The tribunal as well as the High Court have not considered the above mentioned provisions, have committed a mistake holding that since the department acquittal this provision. So this is as regards my lord, Shankar Ghosh case. Then another judgment is judgment of the excellent. Shankar Ghosh. Bahadur, it is length. Page number 11 and 12. Same thing, my lord. Page number, paragraph 11 and 12. Small
paragraph 11 and 12.
Small paragraphs, my lord. One more, my lord. Chitala Misra. Paragraph 14, my lord. Paragraph 14. Relevant paragraph, paragraph 14, my lord.
Yes. That's all?
That's all, my lord. One thing. I'm coming to one judgment I could trace out, my lord, that is 2011 Supreme Court, my lord. Criminal trial, acquittal. Lot of judgments up to 2011 are collated there. I'm just keeping it, if necessary.
Multiplying.
Not necessary. Because 2012, up to 2012, what are the judgments there? In this chapter, Supreme Court collated all the judgments and came to the finding it cannot be. Then, my lord, let me distinguish, my lord. The Tara Singh case were there placed.
Yes, Tara Singh.
Tara Singh case is cannot be applied here. It is a division bench judgment of this High Court. Here, Tara Singh case, the adjudicate, that is there. Tara Singh case, the inquiry officer himself defended the prosecution as well as the delinquent officer. That is why let us come to the paragraph 16, man. Last paragraph, 16 and 17, man.
Yes.
There, my lord, we earned to the decision report wherein the Honorable Apex Court held the defendant inquiry officer is a procedural authority and he is in the position of independent adjudicator. He is not supposed to be representative of a department.
You are reading paragraph?
Paragraph 16, madam. Tara Singh.
There is no such 16. I have given the Manupatra.
Tara Singh, my lord.
Yes, Tara Singh Manupatra.
Last Manupatra was the last paragraph before the last paragraph, my lord. That is submitted by yourself. They have submitted.
Yes.
Last paragraph before the last paragraph, my lord.
You read the sentence.
We are armed with the decision.
We are armed with the decision. This is the last
from that I'm reading.
Yes.
We are armed with the decision reported this, wherein the Apex Court held that an inquiry officer is a quasi-judicial authority and is the position of an independent adjudicator, like a judge, like an arbitrator. He is not supposed to be representative of the department and department, disciplinary authority, government. Even in the absence of delinquent official, he is to see as to whether the undebatted evidence is sufficient to hold that the charges are proved. Here, same person, there no representative was engaged, defense representative, and the prosecutor also did not engage with it. He himself did it. So that is one of the causes setting aside. Secondly, my lord, the main conditions. Here, my lord may come to paragraph 3, fact. Paragraph 3. Here, what should happen, my lord? Here, they started dogs. He is a constable. He is coming out for the factory. In the back, there were several things were there. And paragraph 3, my lord. Only a small paragraph. Paragraph 3, in the interest of effective adjudication, got it, my lord? Got it. In the interest of effective adjudication, factual aspect needs to be recited. Filtering out the unnecessary details, fact of the case in a capsulated form is such that the appellant herein was the constable of CISF, and while he was leaving his place of duty during wee hours, he was found an unauthorized possession of 25 packets of bearing coa made in Japan, 813 numbers of such microbottom cells, and 19 packets of door viewers. While checked by ASI K.R. Patel, such act of the appellant according to the authority amounted to misconduct, violation rules, becoming member of the family. And then, my lord, these documents those are labeled that time. But when trial came, no label was there. So for that ground, my lord will come to say at the time of hearing, my lord, at the time of hearing appeal.
Yes.
Many things are stated there. Anyway, I'm just paragraph 6, my lord. At the time of hearing the appeal, learned counsel appearing on behalf of the appellant vehemently submitted the judgment passed by the learned trial judge absolutely is without any basis, and the law settled by the Honorable Appeals Court has been misconstrued by His Lordship. He further submitted that the alleged charge framed by the disciplinary authority was such that this appellant was found unauthorized possession of certain articles here. But the judgment passed by the Chief Metropolitan Magistrate is quite different. The learned Chief Disciplinary Magistrate Calcutta, after taking evidence of persecution of witnesses, came to the finding that there was no labels pasted on the articles alleged to have been seized from the possession of the present appellants. PW1, the criminal case, stated that there were labels pasted on the articles, but at the time of hearing before the learned Chief Magistrate, he noticed that no labels were posted there. Accordingly, the learned Chief Magistrate held that this presupposes the articles showing seized articles leveling the same to be stolen property has not been actually so leveled as such by the CS of the authority. There is no doubt and an uncementable feature which cannot be bridged show to rope in the accused to the allegation. So these are the things, contradictions. Which was seized, was leveled, but at the time of trial it was not found. So seized documents, seized articles could not be proved that it was seized from him. And another is authority, who inquiry authority, he himself acted as a prosecutor and also defender. That is also permission. So Tara Singh case in this particular case has no way applicable. No way. Factual are completely different. This Tara Singh Malad, then Malad. These two judgments are there. So this is then Malad. And I've already submitted the proceeding which took place that can be taken on record. I've submitted that. So at the end of it, my lord, my conclusion is that all evidences are produced. He has never raised any issue before the disciplinary authority, neither before disciplinary authority nor before appellate authority, that he did not have the opportunity to look into these evidences. Yeah. That is the most important thing. Unless he raises the point of appellate authority, he cannot come to the court. There is settled proposition. So he has not raised that issue, that these documents were not given to me. Only punishment to be reduced. That is the only thing he told.
What is the punishment?
Punishment to be reduced. That is in the appellate authority order. Appellate authority order. Kindly look into the appellate authority order. His representation to appellate authority. He never raised the issue. Nowhere. Is the appeal before the appellate authority.
Page 89.
Appeal. That is my lord, appellate authority order. 1 second. 1 second. Appeal to
89.
89.
Page 89.
Let me look into that. Page 89. No, page order. This order. I am saying that what is submission with the appellate authority. That is prior to that ballot. That is page 83 onwards. Page 83 onwards. Nowhere my lord will find that he raised as any doubt in respect of the production of the documents and evidences. Only reduce the punishment. His submission was there. That is way back in 2001. From 83 onwards, my lord, his appeal. He had never submitted it before the appellate authority. I am not talking about appellate authority order. I am talking about his submission. He never raised the issue before the appellate authority.
What is the order of disciplinary proceeding?
My lord, that is the page. Appellate authority detail.
Not appellate
82.
authority, disciplinary
82 is operative order, operative part of 82. And forward it on page 80. Page 80 order was sent to him. Operative part of the order is page 82. And detailed order with the appeal authority, which was not dealt with by the dispute authority, appellate authority dealt it in detail. Then, my lord, before the appellate, I am also saying that before the appellate authority, before passing the order of dismissal, even before the dispute authority, he did not raise this issue. That is page 76 onwards.
Yes.
As regards documents and other things, who is now reopening it after 2001, when appellate order was passed. Now 2017, my lord, he is raising the issue after the acquittal of the criminal court. I am saying before the dispute authority did not raise it. Page 76, well, page 76 onwards. My lord will not find that. Neither before dispute authority nor before appellate authority clearly, nowhere, only reduce the punishment. I am with my family, etc., etc., all these things. Documents are not given, all this is saying is not correct. That is why I had to I found much difficult to find out the proceeding copy, my lord, because it was a proceeding of 2001. Preservation record rules is there. Anyway, be that as it may, I could not trace her. Anyway, ultimately I got everything.
What is the bank rule regarding punishment?
Punishment, my lord, that is a page 80. That is after that, 76 is the before punishment. He made a representation to the bank after before the inquiry. Then punishment is.
No, I want the rule of the bank.
Rule of the bank, yes, well.
Rule of the bank regarding punishment.
Yes, well. That is in punishment is rule is in terms of 69(1) and 69(2) of the State Bank of India service rules, you may appeal. No, this is appeal, my lord. Then he was 67J.
Have you annexed the rules?
No, I have not. They have not existed.
You have not annexed the rules?
No. I am placing the rule, my lord. আছে সাবজেক্ট আছে আগের দিন দিয়েছিলাম হ্যাঁ
আমি সাবমিট করেছি
করেছিলাম
ওকে
I have referred also.
That's why I'm asking whether you have submitted.
Yes. 67J is a major punishment, my lord, firstly.
Rule 67
J.
J.
Punishment is order rule 67J. Unbecoming of this officer.
67J.
Major punishment, my lord, that is in page number 55 in my book. Minor penalty is up to A to E. Major penalty is this, removal, then dismissal. And misconduct is earlier value. Earlier stated. What are the misconduct? Which is misconduct? Which is major misconduct, minor misconduct, all are examined there. In the rule is provided there. From page 50 onwards. Jail observe good conduct, discipline, integrity, diligence, and fidelity.
Now, in discipline and appeal, rule 67H, H is dismissal.
H is compulsory retirement, my lord.
Now you see the book.
My lord.
The didn't. No such J is there.
No, that later on possibility was changed, my lord. This is the
Okay.
Removal from service, compulsory retirement. Sincere. No, E, up to E. No. Punishment after amendment, this is the position. What the 67J? ওখানটা নেই 67 তো ওখানে নেই এখানে আছে তো হ্যাঁ ঠিক আছে দিস ইজ দ্য কারেন্ট ভ্যালু ডিসমিশন ঠিক এই কারেন্ট এটা কারেন্ট কেন হবে অনেক কাল লাগে এটা হচ্ছে 2002 থেকে 92 না না ওটার পর তো অ্যামেন্ড হয়েছে না ফ্রম টাইম 92 পরে অ্যামেন্ড হয়েছে তো আপনার তো চুরিটা হয়েছে 2001 সালে 2000 সালে and the charge also 200 we have mentioned that J 67J in the charge punishment also 67J.
So where is the offense provision?
Offense provision misconduct, my lord. That is in 50. Offense provision, my lord. Let me go to the charge, my lord. They're mentioned there. Charge sheet ta kothay? Charge to dekho. Charge sheet ta. And 68 to Roman 2. 68 to the Office 67. Charged up frame logo thari. It was a penalty 67. Penalty.
I want the offense.
Offense is my lord.
Which offense the penalty can be imposed?
Yes, my lord. That is
major penalty can be imposed.
So that is.
Where is the explanation that for these offense major penalty can be imposed?
Charge from a charge, my lord, misconduct. Oh no, 62.
Page 40, does it relate? Page 40.
Page 40. You tell me the rule.
67.
Rule 67.
H is dismissal. I don't know why these two books are getting different.
No, it is in this book. J is dismissal. H is compulsory.
J, as per because this was followed at the time of 57 and J names.
Now, what is the correct book? State Bank of India Officer Service Rules 1992.
That is the service rules framed. Earlier service was there, that is framed. Thereafter, certain amendments were there. And after amendment, this is the present rule. This is the present book.
So at the time of the alleged hearing, whether it was there?
Yes.
So where is the offense? Provisions of offense. Borrowing, debt, buying, selling shares, lending money.
62 to 62 in the charge sheet 62 62.
Submission of statement of assessed liability, insolvency.
This is also from 1992, first day of January.
This is the service rules 1992.
Yes, this is also the same, my lord.
92 তো বটেই তারপর amendment হয়েছে
Amendment, but when it was amended, it was not stated. Probably not in that book also.
First day of January 1992.
This is also first day of January 1992, my lord.
That is original rule framed in 92 first day of January. Thereafter, I found an amendment depicted. All the amendments are captured in this book. If this is
The retrospective effect is given.
92, if it is within 92, 92 and 2001, if it is done,
Also to be considered.
if it is done 92 to 2001, then
Aha.
anyway, discipline. Anybody J or H, that
Our
is there.
law.
No, the charge was
When it was
that's right.
amended.
They kind of one
Nothing
class
is
question.
written here, my lord. When it was amended.
It is my lord. In the charge frame, I find
Here submissions won't do, my lord, in this. It has to be written. When this new law was framed, whether a retrospective effect was given to me or not, that is also to be considered, my lord.
No, the
on the judgment.
punishment says according to the 67J. But your book, there is no such J.
No, because this was also
That is H.
H is dismissal.
That is H.
But
How
H
can
is
there be
the
a difference?
compulsory of retirement. Compulsory retirement is the H.
According to my learned senior friend, it is a new book,
Not new.
the amended one.
Not.
If both are of 92, then it should be identical, my lord. Not to be identical.
That is not the purpose of confusion. Okay. Let me see the original book. What is the original rule?
Both are not original, both are Xerox copies. Both of these are Xerox copies. Because we were served this, and based on this only, the whole proceedings were drawn up.
Wrong. Everything wrong. আপনি কি বলছেন ঠিক বুঝতে পারছি না entire proceeding wrong because subpara is wrong. You are assuming 92, 92 other nothing is done. Anyway, wrong বলছেন wrong বলছে আগে let us try to find out. Suddenly, my lord has raised the question. Let us try to find out the answer.
Exactly.
Then here and there making comment, nothing will
Whether
start.
retrospective effect has been given or not.
No question retrospective.
Mere submissions won't do, my lord.
When the punishment was effected, that is to look at. My lord, charge form.
Yes.
If we look into the charges, what is the charge?
That would serve the purpose, my lord.
একটা
That
করে
would serve the purpose. Because which one is the correct book, that has to be seen first.
বার করো না
There are several reasons why I was dismissed. And all those are petty office politics.
to be different by another
Let
employer.
me show. That's why I want to know the what is the offenses.
Exactly,
provisions.
my lord.
Show me the provisions of offenses.
যেটুকু বলছে সেটুকু
What is the provision of offenses that for such
এই
offenses
প্রশ্ন তো আপনি ওটা আগে
the
ওঠাচ্ছেন, এখন
major
ওঠাচ্ছেন।
punishment can be imposed, or for such offenses minor punishment can be imposed.
50 is the conduct rules is 50. That is there. What are the misconduct?
This is misconduct.
Misconduct.
Entirely
There is not like a 50, 50, 1 minute, my lord. I just, these questions will raise, I have never thought of it. Anyway, my lord, but I will have to satisfy. With 60 to 50 কোথায়? Charges কোথায়? Punishment দেখো তো, punishment. Punishment কত বলিস punishment? Punishment কোথায়? কত? 50 is a misconduct. No? 50 onwards. Unbecoming of an officer.
you read rule 66.
66, my lord.
Yes.
Number what, lord?
66.
Hmm.
What is this one?
A breach of any
Yes, breach of any provisions of these rules.
Deemed to a constitutional misconduct and punishable under Rule 67.
Yes.
For the purpose of 51, yeah, this is my lord.
I understand the 67 punishable, 66 is the provision.
66 is the provisions and punishable is 67.
So how minor penalties can be imposed and major penalties can be imposed? Whether
That is
there are
there.
some
Minor penalties, my lord. No, minor penalty is there and there inspection. What is minor penalty? Censure withholding. Censure wastage. Hmm.
Okay, come with a specific instruction.
62. G.
Yes. To come with instruction.
I will just check up. I will find it out.
You find it out.
That is minor penalty. What penalty can be given? That is also stated. And the mention is anyway. No order imposing any of the penalty specified in clauses F, G, H, I, and J of Rule 67 shall be made except for an inquiry.
Without inquiry, that cannot be passed.
Yeah. So without
I
inquiry,
understand, but what are the offences for which the minor penalty can be imposed?
Yes.
And what are the offences for major penalty can be imposed? That I want to know.
Major penalty.
Yes, major penalty.
It
Definitely.
is stated there which are the major penalty, which are the minor penalty.
Another thing, my lord, he has raised pension, provident fund, gratuity. They are saying on the next day they should take time, my lord. Employees pension fund, my lord, if he is dismissed, he is not entitled to pension. That is also, my lord. That is a this is statutory service rules.
Okay, count next day.
I'm not entitled to gratuity.
Next day, my lord.
Count next day. Argument on behalf of the bank authority. No, State Bank of India. Argument on behalf of the State Bank of India, hard in part. Let the matter urgent today. কবে 2 তারিখ করবে হ্যাঁ ওপেনিং second
January, my lord.
Yes.
First day.
Second day of January at 2 p.m. Everything complete?
এটা কোথায় গেল ওটা উঠেনি প্রশ্নটা ওই জাজমেন্ট
2 p.m.
এই ওগুলো কপি করে কালকে দিয়ে দেবেন কালকে দিয়ে দেবেন আমার কাছে নেই আর কপি
আমি